This is a special meeting of the Sunshine Ordinance Task Force called to order at 4:07 on July 22nd. Mr. Young, would you call the first item, or would you call the roll, please?
On the call of the roll, Member Rummel? Rummel present. Member Winston?
Present.
Winston present. Member Wolf? Member Wolf did inform me that he would be late in arriving today. Member Pilpil?
Present.
Pilpil present. Member Hepner?
Present.
Hepner present. Member David?
Present.
David present. Member Fisher? Member Fisher did inform me that she would be late in arriving today. Member Oka?
Present.
Oka present. Vice Chair Hyland?
Present.
Hyland present. Chair Washburn?
Present.
Washburn present. We have a quorum.
At this time, I'd like to know if there's any indication that we're missing some complainants or respondents, or have there been any requests for agenda changes?
I do not have any requests for agenda changes. I believe that the Arts Commission and Mr. Tesh is present. I was wondering, is a member from the Treasurer's Tax Collector's Office present? Thank you. Is the respondent present? Ms. Joanne Adams? Complainant. They are present. For the, is Mr. Kuricolas present? Mr. Kuricolas is present. Is a representative from the police department present? We have all parties present today.
Okay, thank you. Mr. Young, would you call the next item on the agenda, please?
Item number...
Public comment on item 1?
No.
No, let's move right into the agenda, please.
Item number 2, file number 14059, complaint filed by Joe Ann Adams against the Treasurer Tax Collector's Office for allegedly violating Sunshine Ordinance 67.25 and California Government Code Section 6250 for failure to respond to requests for documents in a timely and complete manner.
All right. What we'll do now is the complainant, Ms. Adams, you'll have 5 minutes to speak to your complaint. Oh, I'm sorry, Okay, first we have to determine whether there's jurisdiction in this matter. Has the respondent contested jurisdiction?
No, ma'am.
Okay, thank you then. Do I hear a motion for jurisdiction in this matter?
So moved.
Second.
Is there any public comment on jurisdiction? Okay, seeing none, if we could take this without objection to find jurisdiction.
The motion to find jurisdiction passes without objection.
All right, now, I hope I won't forget that again. This is only my third meeting on the job here. Ms. Adams, you have 5 minutes to speak to your complaint, and then anybody else who's present who has facts and evidence will have a chance to speak for 3 minutes each. Then we'll hear from the respondent for 5 minutes. After that, the matter will be with the task force, and we'll undoubtedly have questions for you. Then there'll be rebuttals and further discussion. So, Ms. Adams, you have 5 minutes.
Okay. May I submit evidence?
If you have any additional documents, I can take that this time.
Okay. And may I tape record?
Yes.
Okay.
The audio recording of this will be online
Okay.
within a day or two, so this will be online.
Okay. Okay. So, as you stated, this is my first Sunshine Ordinance, so I'm not familiar with how to handle it. But I'm going to go into what actually occurred to the best of my ability. On May 15th, I was handed the document that I presented, and that was by Danilo Ampi. And I asked what it was about, and he said he could not tell me what it was about. I noticed that the date was scheduled for a date that I do not work. I work 4/10s, so it was on a Friday. So I went into HR and asked them if it was mandatory that I attend it on a day off. So they switched it to the second date, which was on the, actually, I've got the dates wrong, I'm sorry. This was on May 7th that that document was handed to me. And then they switched the date of the meeting from the original date, which was, I believe, the 22nd of May 2014 to May 15th, 2014 at 2 p.m. As I said, they refused to advise me as to what this investigation was about. It was very vague. So I had 2 weeks to stress out and wonder what I did wrong, and I had no understanding of what was going on. I had never had that happen to me before. Then, when the meeting occurred, May 15th, 2014 at 2 p.m., I brought Larry Stevens, which is my shop steward, in with me, and the meeting consisted of Guillermo Tapia as well as Joni Yakamura, and they're both personnel analysts, senior personnel analysts in HR. To digress a little bit, we had sometime in December, we were required to read modules on sexual harassment. All of the office for the entire treasurer and tax collector was required to complete that and understand it, and then submit an email to a party confirming that we had read it and fully understood it. So the meeting began with Guillermo Tapia stating that he inquired as to, he gave a Q&A about what is my name, what is my title, what is my job function, do I understand the meaning of harassment, do I understand the meaning of sexual harassment. Then Joni Yakamura immediately, the manner in which he stated this to me immediately stated that I had been accused by a Sutanto Dorsano of patting him on the behind in such a way of making him feel uncomfortable in an unimaginable way. And the way she stated it to me, I was very offended. I'm a mature woman, I come to work, I'm very professional. And I remember the incident, and that's why I presented the evidence of the photo. Our area is very congested, and what happened on May 1st regarding this accusation was that I was attempting to pass Sutanto as he stood in front, sort of blocking the way, and I accidentally touched him, and that was it. Now, this man has not said good.
Excuse me. I'm mindful of the time, and I want to make sure that you reach the point where you can tell us about your complaint and the records you were seeking.
Okay, so at the end of this interrogation, when I asked for the minutes of the meeting, I was told by Guillermo that there would be no writing, no memorialization of the meeting, unless he decided to go forward with a Skelly hearing. The interpretation of a Skelly hearing is a termination that's the way we interpret this. So he refused to provide any minutes of the meeting. There would be no resolution. I would be left hanging with this innuendo that I had done what I was accused of doing, and there would be no statement of what the hearing was about, the investigation that took place to that point, and a finding of the investigation. There would be none. The only other alternative would be, as I said, the Skelly hearing, which is a termination. Now, my understanding from the other parties that I've spoken to, legal counsel, there must be some form of writing as to what the outcome is of this investigation, and that's what I'm seeking. Confirmation or denial, what have you, a writing, a memorialization of what the findings are, because it should have been a thorough investigation.
Thank you. You'll have some other opportunity to speak. At this time, is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent. You have 5 minutes.
Thank you. Okay, I think probably everybody has read the complaint that the complainant submitted to the Sunshine Task Force. In her complaint, she seeks the allegation that was filed against her to the Human Resources Department and meeting minutes. Those are the two records that I could see she requested. I conferred with the Human Resources Department. There was a written allegation filed against the complainant. That allegation is considered a personnel record. Personnel records are not subject to public inspection under the California Government Code, Section 6254, subsection C. Further, an allegation is a confidential record and not subject to public inspection pursuant to the citywide Employee Personnel Records Guidebook. For these reasons, the written allegation filed against Ms. Adams was not made publicly available for her to inspect. It is my understanding that there are no meeting minutes concerning the meeting that took place on May 15th. And for these reasons, we have no records to turn over to the complainant at this time.
I'm sorry, I didn't ask you to identify yourself.
Yeah, I'm sorry, I didn't do that. My name is Stephanie Prophet. I'm the tax collector attorney with the Office of the Treasurer and Tax Collector,
All right.
and I'm the custodian of records.
All right, thank you. Is there anyone here to offer facts and evidence in support of the respondent? Okay, seeing none, the matter is with the members of the task force. For questions for either party?
Just a general question. I don't know about you guys. I'm kind of confused as to the timeline. The background is written backwards, so it seems, and maybe I'm reading it, but I'm trying to see whether if there was a violation, how to determine whether there was one that was timely, and if so, what were the actual dates? You know, May 1st something happened, May 7th she was handed something, May 14th she had a meeting, May 15th someone touched her, May 23rd was the actual meeting. I mean, I'm just trying to has someone got a better timeline on this than I do?
I think I can walk you through
Okay, thank you.
through the time frame. She had a meeting with the HR department on May 15th. During that meeting, she asked for the allegation and she asked for the meeting minutes. She was informed at that meeting that those records would not be produced. On June 9th, she filed her complaint with the Sunshine Task Force. And on June 11th, we responded reiterating that the records would not be produced.
Okay, thank you.
So,
Member Pilpel.
so a couple of things. First, if everyone's looked at the documents provided, it looked like that was an original, and maybe we should provide those back to Ms. Adams. All right. Then they should go in the file. First to Ms. Prophet. I'm looking at page 30 of our packet, page 17 of the Citywide Employee Personnel Records Guidelines. Subsection B there, access by an employee or an employee's representative to employee personnel records and disclosure of information. Your department has policies and procedures consistent with these requirements for how an employee may access or get a copy of information in their OEPF. Is that correct?
That is correct.
Okay. To your knowledge, was Ms. Adams provided information about how this works and how to seek access to her file?
Yes, and as she stated in her 5-minute statement, in December she was required to follow the city's modules on sexual harassment, and it's very clearly stated in that training session that sexual harassment allegations are confidential and they don't disclose to employees who made complaints against other employees. It's a highly confidential procedure.
Okay. So are you saying that such allegations are not put in an OEPF and are not subject to disclosure to employees even when they request access under these guidelines and under the state labor code?
Yes, it's my understanding that the person who makes an allegation of harassment, of course, would be allowed to see their allegation, but if the allegation is against another person, the alleged harasser is not allowed to see the complaint, the original harassment complaint. They're kept in separate files. There's a separate administrative file, and this employee personnel records guidelines goes into great detail on how each department should manage the OELF files and the administrative files.
So then if the person complained of doesn't have access to the initial or the original complaint, how do they respond to the allegations? How does that normally work?
They understand what the allegations are, but they don't know who the person is who made the complaint. I mean, in this case, obviously she knows who made the complaint because she mentioned the person's name.
Okay.
But normally the original complainant, the alleged victim of the harassment does not have to disclose their identity.
Okay. So even if okay, there certainly are records responsive to Ms. Adams' request, is that correct?
The allegation by the person that felt that she harassed, yes.
Okay. So
There's a written allegation.
So there are some records here.
One record, yes, the allegation.
Okay. Whether or not that record is subject to public disclosure under the Sunshine Ordinance, it may or may not be subject to disclosure to Ms. Adams as an employee, or are you saying it's not?
This request is a Sunshine Acts request, so this is under the Sunshine Task Force and the public records law. So for those reasons, she does not have access to see that document. As an employee, the subject, a potential alleged harasser, I do not believe she has a right to see the actual complaint, allegation.
But you haven't
complaint.
actually evaluated that request because you haven't been properly presented with it?
We have evaluated that request. We evaluated the request and we did not produce the allegation.
To Ms. Adams as an employee,
Correct.
not under Sunshine, but
Correct.
okay. Is there not a way to disclose the record while redacting the identity involved so that the substance of the allegation can be provided to Ms. Adams?
The practice of the Office of the Treasurer and Tax Collector is to keep the allegation confidential.
And is that consistent with citywide policies that
It is.
DHR promulgates?
It is.
Is there a separate document from this OEPF handling guidelines that talks about the confidentiality of such records? Does DHR have something that says this is how we handle such allegations, investigations, et cetera?
I'm not sure about DHR, but the California Government Code under Section 6254, subsection C, specifically states that personnel records are not subject to public inspection.
I understand, which is why I'm
So-
leaning towards not finding a Sunshine violation. But if we wanted to direct Ms. Adams to her potential rights as an employee, I just want to be sure that we're not sending her into a black hole where there's no information that's going to be provided that way either. That's what I'm trying to tease out.
Right, I understand. I don't think that our office would find it acceptable to give the written allegation to Ms. Adams in any circumstances, redacted or non-redacted.
Okay, then let me just, thank you. Let me
Okay.
go to Ms. Adams briefly. So following that discussion, as I say, I'm leaning towards not finding a Sunshine violation because I do tend to agree that a personnel file is not subject to public disclosure under Sunshine, but I'm not reaching a conclusion about whether it's subject to disclosure to you as an employee under your rights as an employee, and I'm not sure that I agree with Ms. Prophet's statement that they would find it unacceptable and that there would be no way to disclose the substance of the allegation. I can well imagine that in the type of allegations that are filed in the city, that the other side should have an opportunity to respond, and that the city should have some process by which the actual allegation is presented, not just a summary.
Right.
So,
And that's two issues. I'm not going to be long like I was earlier.
okay.
Joni Yakamura already broke that code of silence. It wasn't I. She stated in the meeting that it was Satanto and that I had touched him. That's number one. Number two, all I'm asking for, I don't care about the allegation because I can tell you he's done this before. I can produce evidence. Okay, that's not. Number three, the only thing I was asking for is a resolution because the accusation itself, to be called a molester, that's the way I look at it. And just, it's going to die. That's all I'm asking for is an investigation, hearing, the hearing investigation to be completed. And I've been told by every entity that there must be a written finding after the investigation. That's all I'm asking for. I don't care about the allegation. I'm asking for a written finding in my file because I don't like this hanging over me that...
Got it. So I'm not sure that the investigation itself would be disclosed. I would
Right.
say probably not. But you're asking for the final resolution, whether you were found in violation and subject to some kind of discipline or not.
Right.
And you're asking for that either through Sunshine or possibly some other way.
Correct.
So if that's what we're on, then let me go back to Ms. Prophet for a moment. Has there been a final resolution in the matter, to your knowledge?
I am under the impression that it was resolved and no further action was taken.
Okay.
Whether or not there's anything in writing about that, I don't know because that was not
Okay.
requested in the complaint.
Is-
I can find out if there's been some written thing and
And if not, could you find out if there's a way to just put in writing that this matter was investigated and our findings are as follows and no further action will be taken? That would probably take care of it.
well, I can't commit to do that.
Okay. But you can ask. You can.
I can ask if it has been done. If it has been done, I can check into whether or not we can provide her with that record. That's not a problem.
Even if that's not an existing record, even if that means somebody has to create a letter that says, here's,
Well,
Okay,
we're
I
not going to
don't-
create a record that the Sunshine Task or Sunshine
I
Ordinance
understand.
does not require us to create a record, and I'm not going to, obligate the Human Resources Department to do something that maybe would be not their standard operating procedure.
understood. But you get where I'm going. All right.
Right.
I think I'm good.
I'm definitely, we can follow up with HR.
Thank you.
Do other, Mr. Winston, or Member Winston?
So I have a question regarding for Ms. Prophet, regarding the policies of your office. When a complaint is actually finalized and a finding is made on an allegation one way or another, is that finding not memorialized in writing in a finding letter?
I don't know the answer to that.
Well, from my knowledge of Skelly hearings, there has to be a written finding prior to a Skelly hearing, which, from my understanding, is the
Right.
appeal of that. So would that be somewhere in city guidelines that we can
I think you're correct that if there's a Skelly hearing, there is a written determination, but in this case, there was no Skelly hearing. So I'm not sure if there was necessarily a written determination.
Is it standard practice to make written determinations for complaints like this? They seem like they're something that could rise to the level of potential civil or criminal liability. So it's just something that seems like
I'm
there
not
would be-
sure what the standard procedures are. I would be happy to follow up with HR and determine whether or not there was any kind of final written memo or statement placed in her file, and I could provide that information to the board if that would be useful. The complaint to me was very narrowly focused on the allegation or the minutes, and so I looked into those two records. I didn't research what is if the complete process. I was under the impression that it has been resolved and no further action is going to be taken against Ms. Adams. And I believe she's been informed of that, but I don't know how. Sounds like it was verbal.
Thank you.
Our other members have questions or comments? I have a question for DCA COLA regarding personnel files. And I was just wondering your understanding of, under the labor, the California Labor Code, whether or not the information that Ms. Adams was seeking would be something that she could have access to, could inspect, as this would be part of her personnel record.
You know, I don't really feel qualified to interpret the labor code. It was just a provision that I decided to add in my memo because I thought it potentially could have provided for an alternative means for the document that she sought. And if that's the case, I thought it was worth mentioning because in that case you might want to ask the respondent whether or not they tried sharing with the complainant other means that they could go about obtaining that document. But whether or not it would have been effective in this case, the labor code, I'm not really certain.
Okay, just to Ms. Prophet. So, did you let the complainant know about this provision under the California Labor Code, that there was another way to regard her personnel file, such that under this code she would have the right to inspect it?
No, I did not. I don't have the actual labor code that you're talking about, but the only communication I had with Ms. Adams was the letter that I sent in response to her complaint on June 11th, which I addressed to the board. So that's been the extent of my communication with her regarding these records.
Okay. So it's section 1198.5. So if you would want to work with her, which it sounds like you're willing to do, to help her resolve this in a way that respects the process for her, that would be one thing to do, in addition to working to provide a written statement of findings. Now, it's my understanding that you would not need to produce that to us, but it would be something to provide to her.
It's my understanding through this hearing that she really isn't interested in seeing the written allegation, and that what she really wants is to make sure there's some kind of written documentation in her file that states that she was not found to be a harasser.
Mm-hmm. Right, okay. So at this time, do other members have questions for either party? Okay, if not, Ms. Prophet, you actually have 3 minutes to offer a rebuttal or state anything else you'd like to at this time.
I think I've stated everything that I have to share. Thank you.
Thank you. Ms. Adams, you have 3 minutes to speak further about your complaint before us. Okay. At this time, do I hear a motion? Is there a motion? Okay, so at this point, I want to say that we're finding no violation, but we hope that you'll be able to work together so that this unfortunate matter is resolved in a way that's comfortable for the complainant. Is there any public comment on this matter? Oh, please come forward.
My name is Latrell Huddleston. I'm employed with the City and County of San Francisco, the Treasurer Tax Collector's Office Legal Section. And the only comment that I have to make is when certain things happen, when it comes to a person being accused of something, especially with the Treasurer Tax Department, there seems to be an issue where it seems like management has all the tools to do whatever they want to do to us. But when it comes to us trying to find out how to resolve things and work things out. We're not given anything, and basically, we are ignored. And that is my comment.
Thank you. Is there anyone else with public comment on this matter? Okay, finding none, the matter is closed. Thank you.
There being no motion, the matter is concluded. Item number 3, file number 14034, complaint filed by Paula Datesh against Cheryl Page Ritchie and Howard Lazar, Arts Commission, for allegedly violating Sunshine Ordinance Section 67.16, 67.14B, and 67.16. My apologies for repeating. For failing to post either meeting minutes, audio recordings, or both for various meetings in a timely manner, and failure to include the 150-word summary of public comment into the minutes in a timely manner.
First, we need to address jurisdiction. I was about to forget that again. I just want to dive into matters. I take it that no one has contested jurisdiction? All right. Do I have a motion to find jurisdiction on this? I'm going to ask for public, or is there anybody with any members? Okay. Is there a motion to find jurisdiction?
So moved.
Second.
Okay. Is there any public comment on jurisdiction at this time? Okay, seeing none, if we could find jurisdiction without objection. Okay. Moving on to the matter, file number 14034. Mr. Young has informed me, and I gather those of you, in reviewing the packet for today, recognize that we have combined a number of complaints. There were numerous IDRs over a period of some time, and this is having to do with meeting minutes. It's actually a matter we've heard before. So I think what would be fair is that we give somewhat more than 5 minutes for the complainant to speak to us about the complaint. I would give you up to 10 minutes. And then, of course, the respondent will also have up to 10 minutes. So, Ms. Dadish, would you begin?
Members of the task force, I'm going to read a statement. This is not a new thing to the task force, but my concern is over the audio recording. It's a sunshine requirement to audio record all standing policy body meetings. And it doesn't appear that they've recorded from the inception of the Arts Commission, which was in 1932. It's conflicting, and up until 2011 or 2012, I got conflicting information about that. So the hearing today is a result of a 10-year request for information over record keeping and management of the cultural record of the City and County of San Francisco. I've asked for information about both the rough draft minutes and audio recordings of the San Francisco Arts Commission meetings from 1932 through 2012 through various IDRs at over 16 full commission public meetings and by email. The few responses I received were conflicting. It seems that even the commission secretary doesn't know if there are audio recordings, if there's an inventory, where the original recordings are housed, and how they are maintained. This is the cultural record for the city and county, which has been lost for 50 years. In 2012, Mike Dario, street artist, through an IDR, asked for audio recordings of the executive meeting minutes. The San Francisco Arts Commission invoked a 14-day extension. He was told that the inventory was coming, but it did not come. Through another IDR, I was able to get a few rough draft minutes of the executive meetings from 2011, which are included in your packet. One meeting was held by phone. Several others did not have commissioners present. These are meeting violations. And since there was no audio recording, it's almost impossible to even understand what happened. Since the rough draft minutes have not posted for the executive committee in over 10 years, the residents of the city and county did not know what took place at those meetings, how their money was spent, and where it went. They didn't even have an opportunity for public comment. Sharon Page Ritchie told the Education and Training Outreach the last time we were there, and I've been in front of them twice, that she was working with an outside vendor, and it was a priority for her to post the executive committee minutes of 10 years. That was 4 months ago, and no additional minutes have posted. She told me through an email that she was working with an intern to transcribe and post them. Clearly, their move to the War Memorial Building next summer and personal comfort are more important than preserving the cultural record. I'm referring to a CBS News article that was in the packet. It was over their budget. They got reamed at the Board of Supervisors for having chairs of $919, cubicles of $4,000 a piece. It was included in your packet. So if the San Francisco Arts Commission did not begin to record all the meetings, I'm not sure. I didn't get an answer to the IDR before 2011 or 2012, then where are the rough draft minutes? Must we rely on the Commission's Secretary's shorthand version of what took place? Why has this gone on for so long? How are these rough draft minutes stored and maintained? Where's the inventory? How does a member of the public view the original audio recordings? That's for the rough draft minutes. The same is true for the audio. Where's the inventory? Where are the originals housed? How are they maintained? How does a member review the original documents? It's not only me that's had problems. The other people have had many problems over many years trying to access these public records. I'm only left to believe that things would have not been so bad over there for so long if the public would have been given access to the monthly goings-ons of their meetings. Luis Cancel, the former director of Cultural Affairs' bizarre management style, would have been a matter of public record, and it would have been stopped long ago. Note, when things get bad, like the Clark's performance of the last street artists meeting over the budget, the San Francisco Arts Commission decides to cancel further meetings. No executive meetings had taken place for 3 months, and street artists for 3 months. Clearly, the Arts Commission has no interest in conforming to Sunshine Law, and the willful failure to record audio at their meetings for the past 50 years speaks to a deliberate abuse of power. There needs to be some monitoring or control of these people. Since that filing, I sent a few additional requests over the same issue, which were unanswered, and to the Commission Secretary. So clearly they know that they're supposed to audio record. And then there's the issue of the audio recording of the Board of Craftsmen and Examiners. That's a policy body meeting. It meets every month. They set policy on screening criteria for how people are going to be licensed. It does not have anything to do with whether their response that a commissioner is present or not. That's a standing policy body meeting. There must be audio. There has never been audio posted on their website. And then there's the issue of how they post the minutes. There have been many problems. The one that I was speaking of, I was there. I had a written 150-page public comment at a street artist meeting. It did not appear. And their response was, it did appear. No, it did not. Then there was the time when they posted a link to my public comment 5 separate times, and included it as additional documents from the public. It's just, those people need to be educated. This issue with the loss of the audio recording for 50 years, to anybody who lives in San Francisco, would be concerning. And the fact that they don't stand up and say, we don't have it, is even more of a concern. I've filed several petitions with the supervisor of records. Well, do you have an inventory? Do you have this? Do you have that? Nothing. You get nothing from them. And that's what's most disconcerting. So, I've been at this for a while. I first came to know about it, easily 10 years ago when I was in New York. And, when you're away and you want to know what's going on in another city, you know from reading the minutes. And when you don't see executive meeting minutes, you wonder what's going on. And that's how it started. It's not just 10 years. It's from the beginning. All right, thank you so much.
Thank you. Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent, you also have up to 10 minutes.
Good afternoon. I'm Sharon Page. I'm the Commission Secretary at the San Francisco Arts Commission. So I would like to focus on the memorandum that was prepared by the task force. I believe you have my letter of June 30th written to Mr. Young in response to the complaint and his cover memo. He sent a cover memo with the various complaints and summarized the various items.
Excuse me, can I jump in for 1 second? We have the June 30th letter. The June 23rd memo that you referred to, I didn't find that in the packet, and I was having trouble.
I'm sorry, June 23rd memo.
Yeah, no, not your fault. I guess I'm asking Victor on this. I'm asking
order.
Victor through the chair.
Thank you.
Okay. Thank you. All right.
I have a June 30th letter from the San Francisco Arts Commission addressing...
And it refers in the first line to a cover memo forwarded to us on June 23rd, 2014. What is that cover memo? Again, through the chair.
Are you asking me or are you asking?
If you have that cover memo, that would be fine.
I believe I do have a cover memo, a copy of it that's not marked up. I have one that I've been scribbling on. So, okay.
It's just to alert us of the complaint.
Yeah, this was forwarded to us with those are the first 2 pages of the document. This was forwarded to us along with the complaint because there were many pages in the complaint, and it was not, I believe that Mr. Young was trying to make clear to us exactly the summary of the allegations in the complaint.
Thanks.
For the record is a copy of a summary of my summary of the various complaints. It was probably done through an email, and I did not place it as part of the file since it was a transmittal of my summary.
Okay. I'm good. I'm done. Thank you.
Okay. So looking at that, there is a reference to November 14th, 2012 minutes with a link to 150-word summary by Ms. Datesh. And the cover memo says, I believe that the 150-word summary should be placed into the body of the minutes. Disclaimer is allowed stating that it is a submission of the public commenter. So my response to that was that this was not a meeting of the full commission. It was a meeting of the Street Artist Committee on November 14th, 2012. And the complaint alleges that the, quote, 150-word summary the public comment should be copied into the body of the minutes rather than attached as a link. It's our understanding that on June 24th, 2013, the Ethics Commission upheld the position of the city attorney, which was advice given to us, that a body may satisfy the requirement to include in the minutes a written comment by a member of the public by either linking to the written statement or by placing the comments in the body of the minutes, so that either of those is acceptable. And just as an additional note, the statement that was actually submitted by Ms. Datesh on November 24th, 2012 consisted of 547 words, not 150, and there were also 2 pages of emails. All of those were attached with the link, so they were available to anyone who wanted to read the minutes. December 12th and December 5th, 2011 minutes of the full commission. That was a complicated transition time, and I'm not sure exactly how I didn't get those minutes posted, but the December 12th minutes are posted now. The December 5th minutes are probably within 30 minutes of being posted. They're almost done, and I just have a couple of things to add and to make them live on the website. Let's see. This November 7th, 2011, and January 3rd, 2011, both of those meetings were postponed, and they are now marked that way. There were several things that showed up properly on the website before the Department of Technology changed to the Drupal system where we're posting our minutes and agendas. So there are some of these things displayed correctly in the old system, and I needed to go in and change them so that they now display correctly in the new system. So I did take care of those 2 things. The Community Arts Education and Grants Committee meeting, that meeting of August 14th, 2012 was canceled. Again, this displayed properly in the old system, and I went in and made the change so that it now displays properly that it was canceled. January 11th, 2011, there were 2 meetings listed, or 2 agendas listed, and this was one that did not display. I believe there was a draft, and then the final agenda. In the old system, the draft was hidden. Something about the new system made both of them display, so I went in and got rid of the incorrect one. On the executive committee, I am still working on clearing that backlog of the executive committee minutes. I have made a little bit of progress on those, but I am still very much working on them. And as to the audio recordings, based on the advice from the city attorney's office that the committees are subsidiary bodies and they are not bodies named in the charter, that we were not required to make audio recordings, and so we did not record executive committee meetings before January 2012. And notwithstanding this position, we did begin making audio recordings in January of 2012, and all of the audio recordings for the executive committee that were made since that time have been posted on the website. And this is this position from the city attorney's office is based on the language in the records of meetings in the Good Government Guide, section G1. Each board or commission listed in the charter must audio record regular and special meetings. Other policy bodies are not required to audio record their meetings except for closed session portions of the meetings. So that was the advice on which we were working up until January of 2012. Okay. Street Artists Committee of January 11th, 2012 and March 9th, 2011 the meetings were canceled. These, again, displayed correctly in the old system, and I went in and changed them so that they now display correctly that they were canceled. Visual Arts Committee, December 21st, 2011. That meeting was canceled, and likewise, I made the change so that it displays correctly. The Street Artist Liaison Committee was created by the full commission for a limited time period, and it no longer is in existence. Its time period sunset. And we have updated the website to indicate that it is no longer an active body, and that the November 4th, 2010 meeting was canceled. The Performing Arts Committee is no longer active, and I've updated the website accordingly. The Advisory Committee of Street Artists and Crafts Examiners. This committee is not composed of arts commissioners, and it is therefore our understanding that the administrative code does not require audio recordings, nor any posting of any such audio recording. Nonetheless, Street Artists program staff does make audio recordings of the meetings, and the public may have access to those recordings on request. The nominating committee meets once a year. Those minutes are part of the backlog that I am working to clear. I expect to have them posted by the end of this month. Special meetings is a category on the website. Includes a committee that met only a couple of times in 2009, and we are going to need to work with the Department of Technology to ensure both that the minutes are available, but to make clear that this is not an ongoing committee. So I'm working with them on that. The Arts Task Force is a separate body from the Arts Commission. It was created by the Board of Supervisors. It met for a limited time, and it no longer exists. The Arts Commission was requested to give administrative support, which included posting agendas and minutes, and those were written by members of the task force and not Arts Commission staff. The Arts Task Force did prepare a final report, which it submitted to the Board of Supervisors, and that is posted on our website in the annual report section. Let's see. And I think, let's see. So the memorandum for today's meeting, and I've addressed the Street Artist Liaison Committee, the Craftsman Examiner Committee meetings, Community Arts meetings, the San Francisco International Airport, General Hospital, and SFO meetings, the Randall Museum. These are selection panels and not policy bodies, and so it's our position that those are not required to be audio recorded or to have minutes posted.
All right, I will give you another minute or so since you had to pause and answer Mr.
Okay, thank you.
Pilpel's question.
Let's see. The rest of the committee meetings, I believe, with the exception of the executive committee meetings that I'm still working on, I believe that we are up to date with all of our committee meetings. And I think, did you want to?
Just maybe reiterate some of the technical challenges with the transition.
Yeah, my colleague reminded me that we have had some challenges with the Department of Technology transition. So we were accustomed to working with one particular cumbersome system, and we transitioned to another cumbersome system that was cumbersome in a different way, and did not have quite as much training as we would have liked. So that was one part of the awkwardness of getting everything up and running as quickly as I would like to. So if you have any questions, I'm happy to.
In a few minutes, I just wanted to now ask if there was anyone here to offer facts and evidence in support of the respondent. And you'll have up to 5 minutes.
Good afternoon, Kate Patterson, Director of Communications, San Francisco Arts Commission. I just wanted to reiterate a couple things that Sharon touched upon at the very end with regard to the complaints listed in the memorandum that was sent on July 18th, 2014, where several of our selection panels were cited as being in violation of the Sunshine Ordinance. Those are not policy bodies. One commissioner serves on selection panels. Those panels are created to make decisions about public art projects at various sites, and we do not record those, nor do we take minutes. We take notes, so we capture what occurred at those meetings, but that is, you are not required to post audio or minutes from those meetings. And that's all I wanted to add. And also, I take that back. Howard Lazar is here, so if there are any remaining questions about the Street Artists Advisory Committee, that is also not a policy body, and he is available to answer questions related to that. Thank you.
Thank you.
Chair Washburn, I have a point of order.
Yes.
I'm just curious. A member of the public passed you a note during the proceedings. Does that note have anything to do with this issue or anything on the agenda tonight?
No, it wasn't passed to me.
Oh, I'm sorry.
And the answer is
Excuse me. I'm not talking Member Washburn. Thank
me.
you. I just want to know if it had Chair Washburn. Excuse me, if it had anything to do with the issue at hand or anything on the agenda this evening.
Not that I know of. It wasn't given to me.
Okay.
The answer is no.
Would you like me to answer that?
No. Member Highland has taken care of that. Okay, at this point, I'd like to open this matter to members of the task force for questions of both parties. Member Highland. Vice Chair Highland, sorry.
Through the chair. First of all, I just want to say thank you, Ms. Page Ritchie and Mr. Lazar, for making yourselves available. I think it's very good that you both came. We've heard many complaints regarding the Arts Commission. It's nice to have you both here. I'm encouraged by a lot of what I heard, that I think a lot of work has been done to repair these holes, so to speak, in sunshine and reporting. I'm still inclined to find violations of 6, 7, 14, and 16, just for the record, but perhaps move from there and refer it to another committee just to make sure that they do catch up, so to speak. That's just my initial take. I'm just curious to see if other members had any other viewpoints.
Well, before we just start discussing motions, I'd like for us to make sure we have all the facts and evidence and have learned everything we can from the parties. Member Pilpel.
I tend to agree with Vice Chair Highland on this. What? Oh.
Vice Chair Highland.
I'm expressing that I agree. It's not a question. I'm just wondering, Ms. Page Ritchie, we had heard before about the backlog in your efforts to clear that and post draft minutes, et cetera, et cetera. I'm troubled because we've gotten this series of complaints from Ms. Detesh that we're now addressing. Some of these go beyond what we understood to be the backlog, and I hope that this is everything, and I guess I'm just expressing my concern that we shouldn't have to act just based on Ms. Detesh's complaints, that it's actually your obligation and the Commission's obligation to maintain these records, the agendas, the minutes, the notices, that's appropriate fashion. And I don't think this should be a game of gotcha. And I know that the Arts Commission has a lot of committees, and I'm just frustrated that we're having to see this again. And I hope we don't have to do much more of this at all, ever, going forward.
I would completely agree with you. It is my understanding that all of our minutes and agendas for the full commission, except for the one December 5th, 2011, which I'm hoping to get done before I go home tonight, and the executive committee minutes that I spoke with you about, that all of the remaining committee and full commission minutes and agendas are posted on the website. That's my understanding of where we are now. If there were meetings that were canceled or were not held, that those are properly labeled now. As for the audio recordings, as I said, it was our understanding, based on advice of the City Attorney's Office, that we were not required to, and so we did not record committee meetings prior to January of 2012.
But you are now recording.
We are now
all
recording.
committee meetings.
We are now recording them
And the
digitally,
audio of
and
those meetings since
is
2012
posted.
is all available?
Yes, is posted on the website.
You made reference in your reply to the Street Artists and Craftsmen Examiner Advisory Committee, and that those audio recordings are not posted but are available on request.
They are available on request, and I'm happy to ask if
there-
Mr. Lazar has.
If there's a public request to post them and you have them, is there some huge barrier to just posting them? At least the ones that you have?
I don't know the specifics about that. I will have to check with Mr. Lazar. I believe those are, many of them, I believe, are not digital audio. They are cassettes, and so they will need to be transferred to digital audio, but I'll
Are
defer
you
to
no
Mr.
longer
Lazar.
recording anything on cassette tapes? Is everything being recorded digitally?
Yes, that's my understanding. Yes, as far as I know, for all of the committees, we are recording everything digitally.
So going forward, there shouldn't be a problem?
That's correct.
Okay. All right. Anyway, thank you. I guess, again, in summary, I'm agreeing with Vice Chair Hyland. If we find a violation, I don't care which committee it goes to, but I think we need to sort of put to bed how the Arts Commission goes about this and just get it fixed and dealt with going forward. I'm done. Thanks.
Okay. Other members, do you have questions for the parties? Okay, seeing none. The respondent, you have 5 minutes for a rebuttal or two. Not really a rebuttal in this case, but for additional comments.
I'll respond on behalf of my colleagues, Kate Patterson-Murphy, Director of Communications. Thank you for recognizing our efforts to bring our records up to speed. It's a daunting task, but we are committed to seeing it through, and we will continue to work on it so that all of the existing records that we have are represented online, within a certain period of time. Obviously, we will not be, we don't have audio recordings from 1932, and all of those minutes can be found at the public library, but we will continue with this effort. Thank you.
And I would add one thing about the digital versus cassette recordings. I am working with an intern we have full commission recordings on audio cassette from the beginning of my tenure, which is 2004. In the office, I'm working with an intern to move those from cassette recorder to digital, and as she's finishing those, I'm going to be posting them on the website. I am working with our office manager to determine whether we have prior audio cassette recordings in off-site storage. I have not located any audio cassette recordings earlier than the time that I began working at the Arts Commission. So I'm working with her to determine if there's anything in off-site storage.
When did you start working with the Arts Commission?
2004.
Okay, thank you. All right. At this time, the complainant has 5 minutes for a rebuttal.
I'm sorry, but I've been hearing these kind of responses for quite some time, going back to 2011 to the original IDR of Mike Adario, where he asked for an inventory of the executive meeting audio, and he got nothing. They invoked a 14-day extension, and that was it. It was over. So they're a little, it was a little blip, the Department of Technology or blame shifting or whatever. This is a long-standing thing. As recently as the last full commission meeting, I lectured to them again. Don't you recall that member Pilpel said it's very easy to put skeletal minutes up from the agenda. You can post draft minutes. They already have full minutes up without even being approved at the full Arts Commission. So it just goes on and on. Their mistakes are ongoing, and they really need to be monitored by some outside agency to ensure that they comply with the law, because in my view, they've lost the cultural history for a very long time. I have spent hours and hours in the government section of the public library. There is no record of audio. There is no off-site record of audio. There's not even minutes. There's a requirement to put 2 copies of minutes, one in a binder and one some other place. Years and years of not that. The last Community Arts, Education, and Grants Committee, minutes still haven't posted. That's a violation. I mean, I feel like I'm the arts police. I feel like I'm constantly correcting them. The street artist meeting should have been posted like this. Public comment was 150 words. That should have been in the body of the minutes. The additional documents should have been at the bottom. Additional documents by a member of the public. All this blame shifting and this and that is just so far from the truth. They are in violation of 6716 and 6714, I believe. And I'm going back as far as Hope Johnson in a letter that was on the table when you guys took as new people. She brought a summary to you that when the Clark brothers first came forward with one executive meeting violation and order, that they were personally attacked and berated. Well, that's real progress because that's what they were doing to me in the beginning. And now they're just blatantly outright lying to you. Where are these audio recordings? How are they housed? How are they maintained? This is a record for the city and county. These people are tasked with keeping the record, and they have lost it.
Thank you. At this time, the matter is back with the task force for a motion.
I would make a motion through the chair to find violations of section 67.14 and 67.16 and to refer this matter to compliance and amendments or EOT if that's more appropriate, but I would be happy to follow up on this with compliance and amendments.
Second.
Okay, we have a motion and a second. Any discussion from the members? Now, this is a tricky one, whether to send it to EOT or compliance and amendments, but I'm leaning towards compliance and amendments. So, and right now I'd like to hear public comment on the motion before us.
Good afternoon, Chair Washburn and members of the task force. I'm Patrick Manetzaw. I'm here on my own time. And no, Mr. David, I did not try to influence a member's discussion by slipping him a note. It's below my sense of ethics. As you will recall, Kit Grant and former Vice Chair Fisher complained bitterly about the number of members of the public who file repeat complaints.
Point of order, Chair.
Wait a minute.
Is this really?
You cannot interrupt me while I'm speaking. Stop it. Stop the clock.
Let's see where this is going.
I have to, before Victor restarts that, I have to seriously complain about the behavior of members interrupting testimony when I know.
Okay, let's be as politic as possible here, please.
As I said, there was some bitter complaining about the number of complainants picking on certain departments. But if you analyze the complaint log that Mr. Victor Young sent me, the Arts Commission is right up there at the top of the number of complaints filed against city departments. So I am speaking in support of this motion, Ms. Fisher, to get to my point, because I believe Paula and the Clark brothers have done admirable work as citizen watchdogs, monitoring a really out-of-control department. And the reason I say that is because there's another section of the Sunshine Ordinance that says draft minutes have to be prepared and available and made available to members of the public within 10 days. That the Arts Commission gets up here and says, oh, We just finished the December 2013 minutes. 7 months into the new year is a little bit longer than a 10-day window to prepare and post and make public to members of the public draft minutes. By the same token, as I've testified here before, the city attorney routinely gives city departments errant advice. Mr. Cola. Just because they are not named in the charter explicitly does not exempt them from the Sunshine Ordinance, and the city attorney knows this. Because the Arts Commission is one of the largest violators of city departments in this town, this new, much more ethical task force needs to vote unanimously, finding that the Arts Commission has in fact violated 6714 and 6716. You need to do it today.
Thank you. Is there additional public comment on the motion?
Yes, hello, my name is Michael Petrellis. I want to speak in favor of the complainant. Listening to her speak about being the Art Commission police, I really empathized with her as a fellow citizen watchdog, trying to follow the money, trying to keep tabs on our public employees. I can feel some of her frustration over the years of trying to get basic information. I'm asking you to support her complaint and to really direct the Arts Commission to rectify its problems now. Thank you.
Is there additional public comment?
Good afternoon, task force members. Thomas Piccarello. I'm speaking in favor of the motion by Member Hepner. Actually, I don't think the motion is strong enough. Far too long, we've seen the Arts Commission come in front of you for the last 3 years. I think the task force has the discretion of finding a serious violation, a willful violation, and I urge the task force to find 6734 violation in addition to the code sections proposed by Member Hepner. One other thing, one way to eliminate your backlog complaints is to deter respondents from coming back every 2 or 3 months. So your orders of determination should be strong enough to deter respondents from repetitively violating the Sunshine Ordinance. That is why I'm recommending a violation of 6734 in addition to the other 2 code sections. Thank you.
Thank you. Is there additional public comment on the motion?
Yes, I'm Peter Warfield, Executive Director of Library Users Association, and my apologies for not having studied this closely and for just having come at the time of the rebuttals. But I do agree with the motion and the prior speakers. There was an interesting mention on page P66 as to audio recordings based on advice from the City Attorney's Office that the committees as subsidiary bodies not named in the charter are not required to make audio recordings. We, the Arts Commission, did not record executive committees before January 2012. Library Users Association, as part of busting open a scam, which was the destruction of the Bernal mural, found that there was a whole range of violations with respect to certainly the failure to have, I believe, any subcommittee recordings at the time we made the complaints, and this body found in our favor repeatedly on a whole series of violations. They argued at the time with respect to minutes on 67.16 that the subcommittee, particularly the Visual Arts Committee, wasn't named in the charter. And therefore, as a subcommittee that was not named in the charter, they didn't have to do. They didn't have the posting requirements for the minutes and other requirements that are referenced with regard to a charter group. The Sunshine Task Force found in Library Users Association favor by saying, as we argued, you can't evade the open government requirements by having the major body that is listed in the charter name subcommittees, which essentially do all of the substantive work, have all of the discussion and arguments, and then the main body just simply stamps its approval. You can't do that. The subcommittees are, as the owning body or the major body from which they have been created, are charter bodies. So when it says as of 2012, they heard from this body around that time when we filed a series of complaints, including, as I say, about minutes and about audio recordings. This body found them at that time in violation, and I believe those were unanimous findings. I certainly hope that you'll consider a willful violation based on that history, and that you ask those of your members who may have a personal recollection, or maybe your administrator, what the history is. But this is not new, and repeated violations and gross violations by the Arts Commission are not new. Thank you.
Thank you. Is there additional public comment on the motion? Any additional comments from the members? Member Pilpel?
Just a question. I think we certainly have evidence as to Ms. Paige Ritchie. The Arts Commission and the committees of the commission are her responsibility, as I understand it, as the commission secretary. I'm just not sure if we have evidence as to Mr. Lazar and his responsibilities here. So I'm wondering, to the maker of the motion, if we want to just name Ms. Paige Ritchie and not Mr. Lazar in this particular matter. We'll certainly talk more about Mr. Lazar in item 5.
I'd be fine with that amendment. My intent is to make sure that there's compliance ultimately. So however that manifests is fine.
Agreed. I wouldn't really raise this issue except for the comments about a potential willful violation, and depending on where compliance and amendments goes with this, it might come back to us as a potential willful violation and a referral to the commission. And I'm just not particularly convinced that Mr. Lazar has a hand in this one.
Vice Chair Hyland.
Just to refresh, is Mr. Lazar not the one-up Ms. Paige Ritchie, or is that not correct? In other words, what?
Ms. Paige Ritchie reports to the commission. Mr. Lazar is a staff member under Mr. DeCaney and Ms. Krell. And he has responsibility for the street artist program and some of its committees, but ultimately, in my view, it rolls up to Ms. Paige Ritchie as the commission secretary.
Okay.
I tend to agree, and at this point, I don't know that I would be willing to go towards a willful violation. If we got to that point, I think then we would have to look at the chair of the Arts Commission. This would be somebody above Ms. Sharon Paige Ritchie, who would have the wherewithal to provide her perhaps with resources that she's needed to make all these records available. So we haven't looked at that, but that's an open question in my mind. So if members understand what I'm saying and agree with it, then I'd like to call for the roll, please, on this motion.
Madam Chair, just to be clear,
So,
are we going to
just to be
amend?
clear, we're not including 6734?
I didn't hear a motion to include 6734.
At this time, but we might in the future. We're not foreclosing.
Well, members, what say you? The maker of the motion?
Having made the
Hepner?
motion and understanding that there is a history of complaints against this commission, that I am not privy to, I'm reticent to make a motion to find a willful violation in light of what appear to be some improvements or some steps in the right direction. I think it's appropriate to find violations for what appear to be clear violations, 6714 and 6716. And if this remains a problem going forward, and I do think that this is an opportunity to be very proactive with enforcement of the Sunshine Ordinance, if this remains a problem going forward, then a 6734, I'd feel more comfortable making that motion at that time.
Okay.
And through the chair,
Vice Chair Hyland?
did the maker of the motion remove Howard Lazar's name from his motion?
Right, yes.
If it's appropriate for the seconder of the motion to propose amending the motion to include 6734, I will do that. Is that appropriate?
Through the chair, can I answer
Vice
that?
Chair Hyland?
I think we're talking about another issue, Member Oka. We're talking about the original motion and whether it should include Howard Lazar. So we're looking for a possible amendment there. And then the second issue is whether we also add on 6734 or not.
Okay, so...
So perhaps the maker of the motion should...
Through the chair, I would accept the based on Member Pilpel's experience and knowledge of the various roles of these people, I would trust that it would be appropriate to make the motion as against the Arts Commission and Sharon Page Ritchie, but that is trusting Member Pilpel's assessment.
Member David?
Yeah, just very, very quickly. I just want to say that I feel that the Ms. Page Ritchie and Mr. Lazar and Ms. Patterson are, really, they seem to be working very hard on this issue, and I just want to acknowledge that. And that does, unless we do not take their testimony at face value, I think I agree with Member Hepner that at the end of the day, what we're trying to do is make sure that we're helping them get the minutes up on their website and to the public, which they also seem to be really trying to do. So I just want to, go down this road with the idea that it feels like we're all on the same page here. And so, anyway, that's it.
Okay, I just wanted to say I've heard many cases against the Street Artists Program and against the Arts Commission, and I think that this is an opportunity for us to provide to ask for some accountability with regard, in this case, to minutes and recordings. And I moving this to the Compliance and Amendments Committee and demanding, in order of determination, setting out clear guidelines for what we want to see, I think then we can begin to see some progress on this. And hopefully we won't be seeing the Arts Commission before us for the next 2 years. That's my sincere belief. And there may be some, like I said, possibility of a problem higher up with lack of resources being provided or guidance. So that's my 2 cents, and I promise I won't lecture very often. Okay. So right now we have the maker of the motion has agreed to remove Howard Lazar from this, and the second, do you agree?
I would have a problem with that, since he's been at the crux of much of the discussion previously. But to move this forward, and if it's going to the Compliance and Amendments Committee for further work. I'd be willing to accept Member Hepner's amendment, if it's an amendment to the, I guess it would be an amendment to the motion.
All right, it sounds like we have
Okay.
an amended motion, and then the second agrees to that.
Okay.
Should we take public comment on the new? I don't think we need to. So at this time, I'd like for Mr. Young to call the roll on this motion. Yes.
Can you repeat the motion?
Okay.
Yes, the motion is to find violation of Sunshine Ordinance 67.14 and 67.16 in regards to audio recordings and meeting minutes. On that motion, Member Rummold. Aye. Rummold, aye. Member Winston.
Aye.
Winston, aye. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Did you call Member Winston? Oh, I'm sorry. I zoned out. Aye.
Washburn, aye. The motion passes.
Okay, this should go to compliance and amendments, and the Arts Commission will be required to provide us with a status report on all of their recordings and posted minutes. Let us know of any at the time of the meeting. Let us know of any outstanding items and how and when they propose to supply them. The tape recordings need to be found and inventoried. So this needs to also be addressed. So what we're asking for is a full accounting of records, recordings, minutes for the Arts Commission and its various committees. So the order of determination will read like that. And the matter will appear before the Compliance and Amendments Committee to see the progress that's taken place. Member Pilpel?
Can we somehow refer to this as a comprehensive review of the Arts Commission's website with regard to minutes posting, so that it's not just what's in the complaint, but if there's some other meeting from 2012 that no one found, that this puts it to bed somehow?
No, that's the spirit of what I want. I mean,
Okay.
that is precisely what
Very
we're
good.
asking them to do, a full accounting, everything. You know, a record of the Arts Commission's thinking and work for the past umpteen years. That it all be accounted for, and there's everything that can be made available is available, and there's a solid plan for the backlog, and we'll see how things are going, and there might have to be there likely will have to be some monitoring going forward, which could happen with the EOT, but we're not there yet.
Excellent.
So, at this time, we're about 35 minutes late, but Mr. Young, would you call the next item on the agenda, please?
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Good afternoon again, Chair Washburn. To Member Hepner and the full task force, I think you need to stop saying that you don't have knowledge of the history. You need to require your administrator, Mr. Young, to provide you with a short summary of each complaint against each city department so that you have some sort of historical knowledge. You can't ignore it. As to when the previous matter gets to compliance and amendments, Chair Washburn, I hope you will entertain naming the right actor, since Member Pilpel keeps attempting to sway who is being named as the complainant. And if during the Compliance and Amendment Committee you determine that it has been willful, I hope you will refer this back to the full task force for consideration of 67.34, which should have been done. Member Fisher, and members of the task force. The last two meetings, I have been interrupted during my public testimony. I knew exactly where I was going with it and that I was tying it into the motion on the floor. I guarantee you, if I am interrupted one more time, I'm going to file a sunshine complaint against the violator, because you have ruled against other city departments and commissions for interrupting public comment when you have no business doing so. That is not an idle threat, it's a promise. Next time it happens, there will be a sunshine complaint. As it's to your next scheduled meeting on August 6th, I intend to come here during public comment and encourage you once again to reread my complaint to the Ethics Commission against Member Pilpel, and I'm going to ask you again for finding or introducing a motion for censure of Member Pilpel. One example of this is Member Pilpel's behavior at the recent Education and Outreach Committee, forcing through his personal opinion and forcing it to be referred to both compliance and amendments and to the full task force, when it was clear that it was his personal opinion and clear that other members did not want that personal document put before the full task force. Thank you.
Thank you.
Hello again, my name is Michael Petrellis. I would like to address the fact that you are 35 minutes late with this item on the agenda. I added up what appears to be at least 6 items estimated to last about 30 minutes. That means this is going to be a 6-hour meeting if you stick to just the 30-minute items. 6 hours? I think that's asking a lot of all of you as volunteers. It's asking an awful lot of the public, too. I don't think this is beneficial in any way to have such long meetings. I would like to recommend that you consider reducing how much time you're going to allot for each complaint, how much time you allot for the complainant and the respondent to make comments, and then take public comments. This process is taking too long. It's a big reason why you have a backlog. And if you are going to set 30 minutes, 20 minutes, or 2 minutes for an item, stick to it, please. It would really be respectful if you would say, hey, we're at the time limit, let's take that into account. The second item I'd like to address is something I've been pushing, as have a number of other members of the public, and that is sunshining the Sunshine Task Force by putting these full task force meetings on Channel 26. I believe that the task force has to make an inquiry with the SFGov TV folks about approximately how much money it would cost to air the full meetings, and securing a room here at an appropriate time, a room equipped with TV cameras. It is crucial that the public can tune in whenever they'd like on video on demand and see exactly what these commissions and departments are doing in terms of hindering the public having access to these documents. And that's it. Thank you.
Thank you. Is there additional public comment at this time?
I have an issue with if one person speaks from the department and they're given an allotted amount of time, then that would imply that 2, 3, 10, 20 people from the department can come in, and they can be given the allotted amount of time also. The complainant is outnumbered. These are salaried people. This is part of their job, and we have an uphill battle here, and we're outweighed simply because we don't have paid employees to come in and speak and back each other up. Thank you.
Thank you. Is there additional public comment?
Peter Warfield, Library Users Association. I think all of the prior comments are excellent and are comments that should be well considered. With respect to the first public commenter, Patrick Monet Shaw, regarding new members not knowing the history that might be applicable to cases, it seems to me that that is the job of your memo writer, the deputy city attorney, who is preparing you, presumably, to have an informed view of what's going on. And it seems to me that would certainly include history that might indicate whether there's a pattern of similar issues with the department. Of course, there will always be new members coming onto this task force. Maybe I should say, God willing, if this isn't the last day it meets, ever. Those people need to also be able to participate productively with the assistance of, after all, you're presumably paying your deputy city attorney. I think that speaks in general to the lack of historical perspective that this task force provides to the public. I think in the past you had postings of your orders of determination and other things, like the ethics department has press releases about what happened at yesterday's meeting. Prompt and clear and in plain language. That would go a long way to helping the public and towards basically shining sunshine on your own actions. Sometimes those orders of determination, 2 or 3 pages long, can end up pretty obscure. And in general, I think there needs to be a lot more sunshine about what you guys are doing and finding. That, I think, also would go a long way to not only informing everybody and but also preventing repeat complaints, which I believe come because there's no consequence practically for the department if they violate once, twice, 3 times, repeatedly, and so on. You need to consider the patterns. With respect to the public comment, I do want to disagree a little bit with both the chair and the member of the public. Time-specific items, unless you wanted to interrupt things, it says this will be taken up as soon as possible. Normally, special orders are taken up when the item at 5 o'clock is completed. And I agree with the outnumbered issue. Also, I think you should give fair opportunity to the complainant to answer questions that you pose to departments, because very frequently that's not done and it's not fair to the complainant. Thank you.
Thank you. Is there additional public comment?
Thank you. I have a question. I don't know the last order of determination you made against the Arts Commission. Was Mr. Lazar included in that order?
No, he wasn't.
No. Okay. Well, then I'm a little troubled because Mr. Lazar is here right now. So if he's named as a respondent, which he was in item 5. And he doesn't appear, and then your rational basis to not hold him responsible because he wasn't here is troubling. Mr. Lazar was named as a respondent. He should have been compelled to give his position as to why he did not violate the Sunshine Ordinance, as alleged by the complainant. He doesn't get to sit outside this chamber, wait till you find him innocent, and then come into this room. That's absurd. I filed a complaint against 5 supervisors, and I expect all 5 of them, or their staffs, to give their reasons why they're not in violation of the Sunshine Ordinance. One supervisor's aide is not going to be allowed to give the positions of all 5 supervisors regarding public comment. Thank you.
Thank you. Is there additional public comment? Okay, seeing none. At this time, I'm wondering what the wish of the task force is with regard to a break. We typically have, well, we decided to have a 15-minute break around this hour, so it's a little bit early, but the next matter is likely to take quite a lot of time, so it makes sense to call for our break now. Okay, seeing no objection, we'll adjourn for recess for 15 minutes, giving everybody a chance to stretch their legs and so forth.
Had to take U.S. Airlines.
Oh, yeah. I used to go with TWA all the time.
I'd like to call the meeting back to order at 6:03. Mr. Young, would you call the next item on the agenda, please?
Item number 5, file number 14042, complaint filed by Paula Detesh against Howard Lazar, Sharon Page Ritchie, and Kate Patterson Murphy, Arts Commission, for allegedly violating Sunshine Ordinance Section 67.25 for failure to respond to various immediate disclosure requests in a timely and/or complete manner.
All right, first we have to take up the matter of jurisdiction.
Can I close this? Because I'm presenting, that's a response, and you're already prejudiced because you see it on your screen. Thank you.
I don't believe anyone is contesting jurisdiction. Do I have a motion to find jurisdiction on this matter?
So moved.
Second.
It's been moved and seconded to find jurisdiction on this. Is there any public comment on the motion? Seeing none, if we could pass the motion without objection. Okay, seeing none.
Madam Chair.
Member Pilpel?
Just a quick item. I know in reading it, Victor, you added the word manner at the end. Can you just be sure that that gets added to the description?
Yes.
Thanks. Thank you.
Before you turn on the clock, I would request that these people stop talking. I'm presenting.
All right, now this matter is similar to the one we heard earlier where a number, I just want to confirm this with the administrator. So, Mr. Young, is it the case that we're combining several separate complaints?
Yes, I did combine several complaints regarding IDRs into this one file.
All right. So, as before, there will be 10 minutes allotted to the complainant, and then 10 minutes total for the respondents.
Thank you so much.
That is the people named in the specifically named in the complaint. Now, I always ask if there's anyone here to offer facts and evidence in support of the complainant and the respondent. Now, that would be additional time. But if you are named in the complaint as a respondent, there will just be 10 minutes total. Okay, so everybody clear on that? I heard what the members of the public had to say about that matter, and they were absolutely correct.
Thank you.
All right. The complainant now has 10 minutes to explain to us what's transpired here.
Before you turn on the clock, Victor, can you read the complaint so I can focus on it?
Item number 5, file number 14042, complaint filed by Paula Detesh against Howard Lazar, Sharon Page Ritchie, and Kate Patterson Murphy, Arts Commission, for allegedly violating Sunshine Ordinance Section 67.25 for failure to respond to various immediate disclosure requests in a timely and/or complete manner.
I think we misspelled Patterson as well.
Patterson Murphy should be named in the complaint.
So the point is, and don't start our clock yet, the item, I'm sorry, I'm reading the wrong item. We're on number 5. Never mind. Okay. Ms. Datis, you have 10 minutes.
First off, I want to be clear that Patterson Murphy should be named in the complaint if she's not.
She is.
Okay. Okay, Howard Lazar cannot read and respond to simple questions or document requests. This has been a longstanding practice not to answer the phone or return calls or emails. More often than not, no one is in the office during business hours, and a simple permit renewal requires repeated visits and hanging around. Howard Lazar's voicemail does not reflect when he was out for several days. There's no redirect. Most of the IDRs contained in this complaint, 12 in total, are answered late or do not answer the complaint. His technique of sandbagging is just a waste of time on many people's part. Often, Lazar forgets to include the PDF attachment, does not repeat the original request in his response, or copies people who have nothing to do with the request, as in DCA Paula Jessend. If I'm not filing a petition, there's no reason for her to even be copied, and I've said that for 2 years, but it falls on deaf ears. I do not get the information requested and file petitions later for the supervisor of records. She's frustrated, I'm frustrated, and all the guy has to do is read and answer the IDR. I've spoken under public comment at full commission meetings about this. I explained that someone other than Lazar should respond. It would save them legal fees, time, and my personal sanity. After 16 meetings of saying this at full commission meetings, nothing has changed. For 22 years, Howard Lazar has had another full-time job as a janitor at the South End Rowing Club. He is required by law to file a yearly statement of incompatible activities with his supervisor. He has filed only once in 22 years. We have no way of knowing if his logbooks are authentic or if the information is taken from previous inspections, as he always walks alone. These are public records and should be made available upon request. In this complaint before you today, I ask for many things. A simple one might be a section of an ordinance regarding size requirements. It's a simple thing. Here's the ordinance, here's the section in the ordinance. Go look it up. One sentence. Instead, I get a long-winded, off-topic copy of a badge given to him by Dianne Feinstein and other irrelevant information. I ask for a current map of streetars spaces. I get a link to an old map, which I could have found on their website anyway. I ask for information on a specific stand. I'm not given it. And more often than not, Howard Lazar forgets to include the PDF attachment, which makes it just so annoying. I told you this. I spoke at the last Street Artists meeting under public comment. I handed the chair a written statement. The statement didn't appear in the body of the minutes. In the past, Lazar did not include a response to a hearing that I was unable to attend, included a link 5 times to my written statement, included my written statement as additional documents from the public at the end, or did not include my public comment at all. Included in this complaint is an email from him. He explains that he is, quote, not required to include public comment in the minutes and is doing so as a courtesy to me, end quote. His mistakes have been going on for years, more than 40, and there seems to be no end in sight. So should I go through these 12 IDRs and here's the IDR, it did not satisfy the request and here's the reason why? Is that what I should do?
Yes, you should let us know the status of these as specifically as you can. That's the basis for this complaint.
Exactly.
As we have it. You've mentioned a number of other things, but specifically if you
Okay, there are 12 IDRs that are included in this complaint. The first one, I'm requesting a documentation on the ordinance for how street artist inspections are done. That wasn't satisfied, as I noted to you, and included in a file is a bunch of irrelevant nonsense, long-winded, off-topic. I'm requesting his statement of incompatible activities for years 1979 to 2014. I got one from 2012. Well, where are the other ones? Read the IDR again. I just satisfied the request. Here's one that they claim was missent under a wrong email. It was sent under the correct email, and I send it to various people because I want to be sure to get an answer. And I know that I'm not going to get one from Lazar, so I send it to several different people. Oh, it just goes on and on. Here we have one of June 11. Read the last line of the response again. No, we fully responded to the IDR. No, you didn't. Read it. You didn't respond to it. And that was a late response. Then there came one to the Commission Secretary on June 2nd. I'm requesting documents about the minutes or about the audio recording. No response. Then we go on to December 3rd, 2013. This was sent to a number of different people. If the guy was away from the office, we already went through the thing about the redirect. There was no redirect, it didn't kick back, and it was sent to a bunch of different people. It wasn't responded. It was sent on the 27th of November. It was responded to on the 3rd of December. It doesn't even near address the IDR. Should I continue? March 19th. I'm looking for emails between a specific street artist and the Arts Commission. What I got was a bunch of verbose diarrhea of a verifiable reason why a meeting was canceled. No response. And always at the end, I'm making this request pursuant to the Sunshine Ordinance and sign my name. No response to that one. March 19th. I'm looking for internal emails, written warnings on a specific stand. No response. May 8th. Again, so many people copied on this. And, okay, he wants to invoke an extension till April 23rd, 2014. But then it died. I didn't get anything. Then we go to the budget, April 25, 2014. I was requesting the budget for specific years, current permit holders, copies of the budgets for those 2 years, dates and times of something having to do with something. Didn't get a response at all to any of these. It was unanswered, sent to the correct email address. April 26, 2013, a section of the San Francisco Police Code that defines the size requirements of street artist stands. No response. Making this request pursuant to the Sunshine Ordinance. Unanswered IDR on April 26, sent to the correct address. Unanswered. April 28th. Specific documents regarding a stand, unanswered. I even called and left a voicemail message for Rebecca Krill on the 429. No response. Another IDR, May 27. Oh, right. They're claiming that I didn't get mail because I gave them the wrong address. So I'm asking, please verify my address. No response to that one. May 27, 2013. Sent to Kate Patterson, asking, what's my address? I have no records responsive to this request. Then we go to Kate Patterson again, May 27. I'm telling her she didn't fill the IDR. I'm explaining to her why. And no, her claim is, we've already provided you with a response. No, you didn't. May 28, 2014. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 specific items sent to Rebecca Krill, who should be named in this, Tom DeCaney, who should be named in it, and an immediate disclosure request that was not answered. It wasn't forwarded to the public information officer, and it didn't kick back saying the person is out, contact this person. It just goes on and on. I'm almost done.
There'll be some additional time for you to.
Thank you very much.
To bring us up to date. Is there anyone here to offer facts and evidence in support of the complainant? All right, seeing none, the respondent has, and other people named in the complaint have 10 minutes total, up to 10 minutes total.
Thank you. I'm Howard Lazar, Street Arts Program Director for the Arts Commission. There were 15 RDRs mentioned in this complaint, and we responded on time, thoroughly, with the exception of only one IDR, and that was due to a medical emergency on my part. However, there was an email redirect to the requester and to anybody, to the public, that I was out of the office until a certain date and could respond. And if the requester wanted the redirect to my assistant, they could have contacted the assistant. Going through these, and I'll go down the list that's listed here. I won't take up all the time saying what our responses were, because I sent you the at least 500 pages representing all this of our responses. So we did respond. They were thorough. The first one, the September 8th, 2013 IDR, it was about inspection policies for street art stands, responded. October 6th, 2013, that was unanswered. It was incorrectly addressed to me, to Sharon Page Ritchie, and to Tom DeCaney. November 27, 2013, I was out of the office from November 27th to December 2nd. And the following 2 days, if you'll remember, were legal holidays. These dealt with so-called harassing phone calls from Datish. And there was a response on December 3rd. The March 19th IDR, 2014, it was about Street Artist John Tanui and Art Commission correspondence. It was about my Street Artist logbook. It was about cancellation of a March 12, 14 Street Artist Committee meeting. And yes, we responded. The April 9th, 2014 IDR, it was about the educational background, and especially in visual arts, about myself. It was about the hours of city attorney between me and the city attorney on consultation. And it was about a breakdown of items discussed by the city attorney and me. Again, responded. April 25th IDR, Street Arts Program budgets of 2012-13, 2013-14, number of Street Arts certificate holders, dates of requests for money amounts sent to the mayor, agenda of the next Street Arts Committee, responded to. April 28th, 2014 IDR, request for warnings, photos, inspections on a street artist named Fama Thion and her stand from 2013 and 14, and I did respond to that, of course. IDR, May 20th, 2014, the respondent, I was out of the office May 19th through 26th due to a medical emergency. However, as I mentioned to you previously, that was there was a redirect on the email to this response. May 28th, 2014, a request for the Datesh file, email correspondence between the city attorney, myself, regarding Datesh, logbooks regarding Datesh from 2011 to 14, responded. May 29th, 2014, unanswered because not received according to its date of May 29th and not shown as an attachment to the file 13042. How can I respond to that? It's not even in the file. May 29th, 2014, this is about Sharon Page Ritchie, about the executive committee minutes, or I'm sorry, the audios, and Ms. Ritchie can respond to that. The IDR of June 3rd, 2014, it was about the return of Daytesh's $170 money order. The reason why allegedly no one answers the phone at the Art Commission. The reason why Patterson allegedly was laughing when Daytesh was speaking at an Art Commission meeting. And the reason why allegedly there's no voicemail when the employee is not present. June 16th, 2014, document emails between Art Commission and City Attorney regarding retroactive payment to veterans, where the funds are coming from, and Art Commission policy for notifying veterans, and yes, this too we responded to, and you have that. And then finally, the IDR of June 17th, not June 16th, which she lists on her complaint. It was June 17th, where she's asking for a resend attachment to the previous email, and we did that, including the attached emails. Now I'd like to turn it over to the other two employees of the Arts Commission.
On the May 29th request regarding audio recordings, I responded to that on June 2nd. May 29th was sent in at after closing hours, and I responded to it the Monday morning. I asked for clarification, and we had a second email to find out what was going on, what it was that she was asking for. I sent CD copies as requested, and had a phone conversation. There's an additional email response on June 16th and June 24th as to the audio recordings we discussed. I talked to you already about the audio recordings that did not exist before January 2012. So that was the period of time when I was trying to find out about that. Okay. Anything else? Yeah, so do you have any questions about any of this?
Members?
We're going to hear from Ms. Patterson.
Are we going to hear from Ms. Patterson?
I have nothing further to add. I think that Howard was pretty thorough in responding to each point and we've already provided the emails that were sent to Ms. Datesh. I want to just note that in some instances, her emails to us are not received because the email addresses she used are incorrect, which is the example I had up earlier. You have all of the correspondence. So as you can see, we did respond to all of the IDRs. Thanks.
Thank you. Members, do you have questions for either party? Or is there anyone here to offer facts and evidence in support of the respondent? Okay, now the matter's with the members of the task force for questions for the parties. Vice Chair Hyland.
Through the chair, just to give some history for the newer members, as you can see, there's quite a log, to use a popular word tonight, of these types of IDRs and compliance, non-compliance, and whatnot. And certainly it seems like the Arts Commission is getting better, I think. I'm encouraged by that. However, it seems like not all the questions have been answered. That much I'm convinced by from what I've been reading. Yes, it was on time. Yes, they responded, but was all the information actually provided in a timely manner? I'm not so sure about that. It would be nice maybe to do something like we did in the previous case number and group these matters into one all-encompassing motion. We'll get there at some point, but that's kind of where I'm leaning on what I've heard so far.
Are there any questions for the parties? Member Pilpil.
I'm not sure if I have a question yet, but just to follow up on the discussion, I tried to read through the hundreds of pages here. I found it difficult. Ms. Datesh frequently uses the wrong email address, the sfgov.com, not sfgov.org, has misspellings of names, so things clearly weren't always getting to the right people. Ms. Detesh often copied Ms. Jessen on things and then complained that the staff were responding to Ms. Jessen. I found all of that difficult. I did find that and most of the responses did appear to be timely. It wasn't entirely clear that they got to Ms. Detesh. And some of the responses didn't seem complete to me, where there were documents requested, the manual, the statements of economic interests or statements of incompatible activities. Those didn't appear to have been provided. There's just a lot of back and forth here, and it's just frankly pretty confusing. Going forward, it seemed to me that it would be a great idea if the Arts Commission would designate a main point person on records requests, perhaps Ms. Patterson-Murphy, perhaps Ms. Licouris as a backup, but that's up to them. And it would be great if Ms. Detesh would simply make all of her requests through that person, have each request tracked, have an acknowledgement back to Ms. Detesh from the staff that they've received it, either assign it a number or do something with it, and then follow up to that specific request. So let me be clear, you were asking for blah, we're working on it, we'll get back to you, and then get back to her. And it's just incredibly difficult trying to follow the trail here. So that's where I am. I'm inclined to find some kind of violation, but I would like this to get fixed going forward. I'm not asking that it go to EOT, but I am suggesting that we try to fix this problem because I think that Ms. Detesh has some legit requests and needs to be able to get timely responses, and that doesn't seem to be working on a regular and consistent basis as it should. That's where I am.
Other members? I have a question for Ms. Stadish.
Yes.
I was overwhelmed by the size of this.
So am I.
Complaint. I read through the chronology. I read it. It appears to me that, by and large, the responses were timely. I don't see a violation of 6725. But what does concern me is the adequacy of the response, whether you received all of the information. I have it electronically, but the file is enormous.
I've even printed it out.
Yeah.
It's enormous, and most of it is irrelevant nonsense. It's a waste of people's time. Can I please point out one thing, not to interrupt you?
That is my email. It was forwarded to me for display purposes only.
Well, see, that further complicates the issue because if you separate the IDRs from the responses and you clearly look at the emails that I send out, every single one was sent to multiple people because at the last full task force hearing, I understood that Patterson-Murphy was now the custodian of records. So just to cover myself, I copy other people. There has never been a redirect. There has never been an acknowledgement that we received it. I don't call. I don't go there. I track it after 24 hours. If there's no response, I'm waiting. I'm looking. I'm making sure my email is clear, that I can accept things coming in. And I have not received most of these things, and they're coming in bits and pieces. So even if... And we've been this route through the education outreach twice, where with the Clark brothers, he goes through an hour-and-a-half rant with some kind of spreadsheet that if anybody gets an IDR, it's immediately logged in and cataloged and this and that. Well, clearly, I mean, they get violated, but they seem to have no regard towards following the suggestions put through by this task force. I'm looking at one in particular, May 28th. Here I have several specific things which are clear and straightforward. I copy several different people. It's clear there was no response to number 6 and number 7. It came late. I don't know where they're coming up with their information because it's wrong.
Member Pilpel.
Let me ask then, through the chair, to Ms. Datesh, what is it that you would like us to do about this? Okay, I think we all sort of see and feel this. What do you want us to do? We're not necessarily going to do it, but what is it that you want us to do? How can we try
Look
to
at
fix
the
this?
broader picture. You have people who are trying to just simply get information. It might be a simple question that might be answered. You might go to the legal department of the police. There's a counter there. You might be patient. You might have to wait. But your question, there's a live person there. And your question might be answered. It might not. You might get the deputy city controller on the phone or somebody else on the phone. Your question's answered. They don't go through the gyrations that we have to go through with the Street Artist Program and the Arts Commission. Here you have Kate Patterson, who's hanging in the wings to deal with the mistakes of Howard Lazar.
Okay.
One email was missent, but other people were copied, and I resent it. Where's the response? I mean, these are emails. It's a paper trail. And the root core of the problem is that the guy can't read and respond. It is voluminous, but if you sift through all that written crapola, is there really any information there? Very, very little.
Vice Chair Hyland.
Ms. Datesh, please. As you heard in the previous case, we're trying to correct this as much as we can in an all-encompassing way.
Agreed.
My feeling is we're going to do this again here for this case, I believe. That's just my personal opinion. We'll see what the rest of the members come forward. I'm going to ask you one favor.
Yes.
And I'm going to, first of all, applaud you on all the work you've done so far to get here and all the things that you brought before us. I would ask you just to exercise a little discretion. I'm not in any way impinging on your rights for Sunshine or your IDRs or anything like that, but just to think about what would be productive or not productive. You have the right to make an IDR for absolutely anything under the sun to do with the Arts Commission. I grant you that. But take a moment and look at the people behind you when you stand up at these stadiums.
That's why I grouped these together.
And I agree. If city departments were better at Sunshine, there would be less complaints. Our backlog would be smaller. I'm not putting the onus on you. I'm just asking for team with us, work with us on this. That's all. We can only do so much.
My main issue is the lack of information about the Street Artist Program. You have not gone to a street artist meeting which erupts into an angry confrontation with a new chair who really just got there and is volunteering her time, only to be almost attacked by the Clark brothers. It's not well run. And if you simply are asking, well, there is going to be a fee increase, what is it going to be? And you're not getting that information, and you're dealing with these, to me, they're background noise. If you have to go to a lottery in the morning and you have the Clark brothers or Mike Addario ranting about how these fees are going to go up to $1,000 and people are going to be knocked out because they can't afford it, are they right? Are they wrong? What's going on here? And if you cannot get information, it's very disruptive, and that's a large part of what's going on here. The meeting's not run correctly, and the lack of information, so you have this void that is filled by other people.
I get that sense. And we get
good.
that, when you
But I'd be happy to work with you, because up until this point, I've been met with frustration always around.
And I think one of the suggestions that came out of this, which I think is a very good suggestion, is to have a dedicated person for Sunshine at the Arts Commission. And I hope they'll take that to heart and they'll rework that, assign someone, reassign someone. It's a start. And in that vein, I should also thank the Clark brothers for all the work that they've done along with you. I mean, we get the sense, we feel it on this side, we do. but, just keep working with us. And
My concern is Patterson Murphy may be the custodian of records. However, she's pregnant, and she's been gone for long periods of time with no voicemail or email redirect. She's pregnant. Who's going to take her place? We need to know these things. We need to know who's the custodian of records. The public, I'm sorry.
Okay, I think it's time now, if there are any questions relevant to the timeliness of the response, that's the main complaint. And also if there are outstanding records. Member David.
Yeah, so this was, thank you. That was exactly my question. What I want to know, Ms. Datash, is that do you believe that there are, and I would like you to be as specific as possible, do you think that there are responsive records to any specific one of your IDRs that has not been responded to? It seems like the timeliness issue has pretty much been resolved. Now I want to get to, do you believe that there are responsive records that have not been turned over to you?
I believe there are many responsive records, but there's also other sections of the code that are more applicable, which is the one to assist the requester in getting the documents. What you get is, here's my email request, we already responded to it. Boom, done deal. Okay. There's never been that. The immediacy of the response, the paper trail, they came up with that long-winded log thing that they don't even produce because obviously they're not using it. What are their provisions moving forward? Who is the custodian of records? If she is, when she's gone, who's going to take the place? Public needs to know that.
I have a question for Mr. Lazar and Ms. Patterson Murphy. Very simply, are there any responsive records that you have not turned over to Ms. Datash for any of her IDRs?
Absolutely not. And I think what's clear is that none of you actually read through all 500 plus pages in this complaint. I mean, we have them all printed out here. In each instance, we are thorough. So I would appreciate if you are criticizing us about not being thorough in our response to point out specific cases where you believe that we failed to respond to the question, because not only did we respond in a timely fashion, but we responded to the best of our abilities where we had extant records. Do you have anything to add?
No. Yes, I do. About the business about the sunshine log, yes, we use that daily. We are sunshine almost daily by Ms. Datish, and that gets recorded immediately along, and we took your request to improve that log, and we came back and showed that to you. So it isn't like we don't use it and that we dreamed this thing up all on our own.
Furthermore, I want to add that it is my understanding that when you receive an IDR that you need to give information on a rolling basis. And in an instance in this deck, we had a very lengthy IDR with numerous requests, and that is exactly how we responded. Some requests were specific to my personnel file, for example, and Howard's personnel file, and we worked as a team to respond to that in a timely fashion. And so I think, with regard to point of contact, I oversee all of the responses that come out of the Arts Commission. I am CC'd on all of them. I keep records of all of them. In some instances when Howard receives such an incredible volume from Ms. Datish in particular, that in order to expedite those responses, we have him just respond rather than creating another administrative layer where it then comes to me and then I create a new email and then send it. To me, that seems more expeditious and a more efficient way of responding in a timely fashion.
So I want to ask one specific question about the economic. I want to make sure I say the form correctly. I think the economic...
The Form 700?
Form 700, right, like from 1979 till she made a reference, Ms. Datash made a reference.
Okay,
yeah.
She did not ask for the Form 700s, okay, and I have that, and I have no problem. In fact, I did furnish her with, I believe, 1 or 2 years that she was asking for. No problem. That's a public record. That's filed with the State Ethics Commission, okay? What she kept asking for was a statement of incompatibility, ability, business, or whatever, which I don't file. That's the Art Commission's policy, okay? Thirdly, As an independent contractor, I was not required to get an advanced determination from my department until relatively recently when the Civil Service Commission changed their rules to include independent contractors. And I furnished that to her. So this has not been ignoring at all.
Thank you. Member Fisher.
Yeah. Mrs. Patterson-Murphy, first off, congratulations. I had no idea. I only see you from here up.
Thanks.
So best wishes for a healthy delivery and child, et cetera. But
Thank you.
Ms. Datesh brought up a good point. What is the coverage plan for you?
We do have a plan that we will be executing when I depart from maternity leave, which is that Howard will be the primary point of contact since he gets the majority of the complaints. Again, in order to expedite responses, it makes sense that he has the most experience responding because of the sheer volume and attending these meetings. And so Howard will be the primary responder. I mean, just because it's usually a street artist program issue.
Okay, thank you.
Yeah.
Thank you. Any additional questions? All right, at this time, you may not want to sit down. You have, the respondent has up to 5 minutes to offer a rebuttal.
Well, again, I would really appreciate if this committee could point to specific instances where we failed to provide the requested documents. I mean, this is a giant deck. There's over 500 pages of emails here, which I even had trouble printing from the website. So I just feel like it's not fair. We have demonstrated that we've responded in timely fashion to all of the requests for information, and then to just assume, or I just feel like there is a bias that we and a lack of recognition on the part of this committee that we are not doing due diligence and responding in the way that we should be, and when we absolutely are and have demonstrated that we have. So I think that before you move forward and accuse us of not providing records, that you point to specific cases where we fail to do so.
At this time, Ms. Datesh, you have up to 5 minutes.
This document that they refer to, their responses of 500 and some pages, if anybody bothered to trudge through it, it's a lot of irrelevant nonsense, not even near approaching the IDRs. They're simple questions that could have been answered in 1 or 2 sentences. It does not require any of this sordid nonsense on his part. That's it. That's that. I edited down this complaint. There are 20 clear, straightforward IDRs that were sent during that time that were also not responded to. This is a paper trail. There's no disputing. Here's the IDR. Here's the date it was sent. Here's the response or the no response. It's pretty clear and straightforward. And with their moving forward plan, that's not a good plan either, because here we have a long-standing history of Howard Lazar not fulfilling IDR requests, not only through me, through Peter Warfield, Ray Hertz, the Clark brothers, Mike Addario. I mean, the list is long, and it goes on for years. So the person who's supposed to be overseeing them, who's not, is going to be gone for some period of time. And who does it go back to? Howard Lazar. Well, you're going to be seeing these repetitive things in front of you unless you can put something in place, which might be monitoring. It might be some mechanism where somebody can arbitrate information. I don't know what you can do, but when you have a long-standing history of one individual not giving up information, that's a real problem. And it's look at the civil grand jury report of 2012. I mean, it was very bad, and it spoke to just these issues. So, you know, moving forward, what can you do? We've been to education and outreach. He came up with some logbook. We don't see it today. We don't know what's going on. What happened to these? Anybody? I mean, this is a waste of people's time. It's a waste of trees. It doesn't mean anything. It's just Howard Lazar. If there's anything you can do, I mean, it's great you find a violation, and I appreciate it. It's some kind of recognition. But you got to get somebody else to fulfill these IDRs, because the guy can't read and write. It's just that simple. He can't. I would like the statement of incompatibility things from 1979 to 2012. We already fulfilled it. No, you didn't. And I don't even bother to banter, because that complicates the issue. The guy has had no sunshine training. 44 years, he sits there and writes these minutes. He's got a history with you people of altering audio tape, messing up stuff repeatedly, late IDRs, unanswered IDRs. And that's only here in this controlled environment. Imagine what he's doing out in the street or up in that office where he's not really supervised. You got to do something here.
Thank you. The matter is now with the task force. Member Pilpel, and then Member David. Oh, no.
I expressed earlier my frustration with the situation. Hearing from the Arts Commission staff that their plan is to have Mr. Lazar be the primary contact does not, unfortunately, make me feel better about this. I suggested earlier either Ms. Patterson-Murphy or Ms. Licouris, but that's entirely up to them. I think, unfortunately, Mr. Lazar has a history with Ms. Datesh, and it's not great, and there needs to be a third party in there. I'm seriously thinking about whether we need to escalate this matter to the Deputy Director, Ms. Krell, or the Director of Cultural Affairs, Mr. DeCaney. I think that we've got to get a better answer for how this is handled going forward, and I think ultimately it's a departmental problem. And I don't see that we're resolving it today, quite frankly. I do believe that there are additional records responsive to Ms. Datesh's requests that have not been provided. I can cite some of those from what I've looked at. I would ask Ms. Datesh if she could make a short list of the documents that she believes haven't been provided. I think that would help. But ultimately, I would like a better process here. I think that it's not just Ms. Datesh and the 4 or 5 other people that she mentioned, but I think none of us are being well served by this process at the Arts Commission. And I'm struggling for how to find a violation and find a process that's going to fix this. So I'm very open to hearing about it, but that's where I am. Thanks.
Now, Member David?
Yeah, so I think we should bifurcate the question that, or the issue that Member Pilpel is raising, right? One is, was there a violation for these IDRs? That's one question in and of itself. Second is that, can we as a task force be helpful in helping the Arts Commission create a better process for sunshine? Those are two different questions, right? I think that the first one is the predominant one that we have to deal with. That has there been a violation of the sunshine with these IDR requests? And I personally, it's really hard for me to see that violation. It seems like that the Arts Commission has really kept great records and showing that they're responsive. And so I appreciate Ms. Datesh's frustration, and I can totally understand from her point of view that it must be very frustrating, but I'm having a hard time pointing to there's the violation right there. That's not to say that we shouldn't be assisting the Arts Commission in creating a better process for the public going forward, but I just don't see a violation on this particular case.
Member Pilpel, you said you could find instances where there were responsive documents that weren't produced. Because I have to admit, when I read through this, I was looking specifically at immediacy of response. I also looked through to make sure that immediate disclosure request was the subject head of the emails. That's what I was looking at. I have to say I didn't sort through all of the many, many pages to track whether the response was adequate. So anyone who has found problems here, please let me know, let us know. Member Pilpel, you said
Let me just point out a couple that occurred to me. A request for all documents relating to policies and procedures relating to inspections of street art stands in the street. And there was some response, but it did not include the manual that was referred to at a previous committee meeting. There's apparently some manual or book that describes the ordinance and the procedures that staff uses to implement it. It seemed like that would be a responsive document. The section of the ordinance regarding inspections of street artists' wares on the streets, I don't know that the specific language of the ordinance was provided in response to that request. That seemed to be, pretty clear to me. The copy of the manual referred to, that was on the May 28th, 2014. I'm not sure that was provided. All logbooks for years 2011 to 2014 of inspections done concerning Ms. Datesh. I don't know if all the logbooks related to her were provided. Certainly there were some logbooks, but I don't know if that was all of them. There were other instances, but it seemed to me like there. Oh, and as to the statements of economic interest and incompatible activities, the economic interest statements certainly go back that period. SIAs have not been around quite as long, but the department should have records going back some period of time, and it seems like they were not all provided. So those are just the examples that I came up with, top of my head. Thanks.
Member Winston.
Regarding the statements of economic interest, I believe those should be on file with the Secretary of State as well, if I'm not wrong.
If I may, on those...
Form 700s.
Because Mr. Lazar is a department filer and not an officer, it's held at the department, and it's subject to their record retention policy.
Thank you. Any other discussion amongst members? At this time, is there a motion? Vice Chair Hyland?
I'm looking for the code for the one that incomplete response.
6721B.
Going with 21.
6721B.
Custodian of public record shall, as soon as possible within 10 days, comply with such request. That would work. I don't think the requests have been completely complied with. I'm willing to find a violation there and propose a motion for violation of 6721B.
Second.
Member Pilpel. So the motion to find violation of 67.21B is made by Member Hyland, seconded by Member Pilpel. Member Fisher.
Members Pilpel and Vice Chair Hyland, can you explain why you picked that? I mean, just your reasoning, because
Just for the list that Member Pilpel just provided, for items that could have been more responsive to the IDRs.
You did offer us a chance to review those, though.
I mean, we could also find potentially a violation of 21C for failure to provide assistance. I don't know. I mean, I don't know where we want to go. We can find specific sections, but...
And where would you go with that? I mean...
I think our intention here is to log it with the intent of it getting fixed, whether it goes to EOTC or complaints. But I think we need to record this and just, move it forward.
What I was thinking is that Member Pilpel has found some specific documents that were not provided, but I would want to ask the complainant to be very specific about what she asked for that wasn't provided. And that would be part of, in preparation for an order of determination. We would have to know what was outstanding so that we could then ask the arts members of the Arts Commission staff to provide that. So we'll get there. Does that make sense?
I'll live with that.
Member Hepner.
Yeah, through the chair, it does make sense to me, and I'm having, the same trouble that I think many of us are having at really ascertaining what may have been withheld. And with all due respect to the Art Commission's representations about compliance with this, it is impossible for us to know that you have complied fully with this. We're hearing Ms. Daytesh's complaint, and I believe that, there's a possibility that there is merit to her complaint, that records have not been produced that are responsive to the requests, and we have no choice but to just believe either of your blind assertions that you have met your burden to produce records, or that she has met her burden to show that records have not been produced. It's impossible for us to know. What is very clear to me is that the relationship between these two bodies is highly volatile and highly counterproductive. I think that some severe, serious mediation needs to go on to cut through the animosity, or else this is never going to get better. And with all due respect to Ms. Patterson, your tone towards the task force is a bit insulting, that we haven't done our job to review the file of 500 documents. I just, it makes me uncomfortable, and it's antagonistic in a way that's not helping this process. I would like to hear the Arts Commission respond to one of Member Pilpel's noticed spots where something wasn't produced. If that's what you're seeking to vilify yourself of, I would love to hear just, does Member Pilpel have one that may be, worth addressing more than others?
If the Arts Commission wants to respond to any of those, that's fine. If I got it wrong, and if it's buried in here, if it was provided separately and I missed it, please tell us. But it appears to me that some of those things weren't fully provided. That was, and yes, I did read the materials.
Well, thank you so much for inviting us to respond to those assertions, because I do think it's fair, if we're going into the content of our responses, that we be able to elucidate and clarify any remaining questions with regard to our ability to produce records. And so, forgive me for my tone. It's frustrating, because obviously with 500 pages of responses, we have put a substantial amount of work into this. And I think that to generalize about the whole deck is, it just seems like it's a little unfair for us to not be able to respond directly to particular questions. So I'm going to turn it over to Howard, because he was responsible for providing some of the records that Member Pilpel mentioned.
One thing that I just wanted to mention was that the business about the 700 forms, I think I just mentioned that to you, that she did not request the 700 forms. She kept requesting, in fact, I produced those for her because she was asking for a certain period of time, and I thought, well, I better give her those, even though she doesn't know the title of it. So I did, and for that time period. If she wants to go way back on those, I'm more than happy to dig those up too. I'm not trying to hide anything. She kept asking for my filing of a statement of incompatible activities. She even asked Deputy City Attorney Paula Jessen to weigh in on that, and Paula Jessen explained it to her. I don't file those. The department adopts that as a policy statement. Okay, I file advanced written determination to proceed in my off-site activity. I get that from the Art Commission, and I gave her that. So it's like, I'm not trying to hide anything. That's just one thing I remember Mr. Pilpel saying. I know I could respond to several others, but at this moment, I just can't remember the others that he mentioned a few moments ago. But I'm more than happy to respond to them, and more than happy to deliver them. but quite often she just uses a certain phrase, a certain statement. I try to figure out what does she mean, and again, I gave her those 700s, even though she didn't even mention that, but I did that.
What about the? Oh, I'm sorry.
Through the chair. Okay.
Member Pilpel mentioned a guidebook.
Oh, I'm glad you. Yes, thank you very much for bringing that up. It's a handbook. It's a Street Artist Program handbook, which is online on our webpage. It's like about a 200-page book. Half of that book is the laws themselves, reprinted. And the other half of the book is an explanation. It's written to a street artist on the process of getting licensed, the process of having your work screened, getting licensed, the different agencies to go through to pay your fees, the process of getting a space on the streets, which is through a lottery system, et cetera, et cetera. And then there's a section on all the maps. But there's not a section on my screening committee or me going around monitoring. Okay, and I remember Mr. Pelpil was mentioning he thought that was included. That's not included. That's not even a section stated in the Street Artist Ordinance. It is implied, and the city attorney has always told us that, yeah, if you're going to give a license, it would be great if your department could monitor compliance with that license. And the first one who totally approved that was Mayor Dianne Feinstein, who issued badges to myself and to my screening committee members to go out on the streets and do it. So we provided that. We also provided the Art Commission resolution authorizing that too. So we did not ignore that. It's just that it's not in that street artist manual geared to street artists.
But you did provide the street artist manual or a link?
No, it's online.
Okay.
Yeah.
Oh, and I just want to point out that this is the email, or one of them in question, and as you can see, all of the email addresses are wrong. So we never even got it. It's howardlazard@sfgov.com, Sharon Page - Ritchie, not even spelled Ritchie correctly, Tom DeCaney's misspelled, and Victor, I think you're the only one who got that one. So.
Member Pilpel?
I mean, I think the manual was actually what Ms. Datesh was asking for, and it wasn't provided.
If that were the case, I would have provided it gladly.
He's speaking to the mic.
I'm sorry. If she was asking for the manual, the actual manual, I have no problem providing that or directing her to the website at the very least.
Okay. There were other requests for the policies and procedures, which seemed to me would probably be in the manual, or if they weren't, just pulling out a 1985 resolution of the commission doesn't seem to me to be a policy or procedure related to inspections, and requests for the sections of the ordinance are the text of the ordinance, and it didn't appear that those were provided. Those are just some of the examples that I pulled.
If I may, you asked for what specific information I requested and didn't get. I did not request a Form 700, and nor did I get them. Unless he can produce this information, the IDR and the request, that's another one of those Howard Lazar things. I requested a statement of incompatible activities from 1979 to 2014. I got 1 year, so I did not get the information that was provided, and it is available in the department because I contacted ethics. Pat Patterson told me that yes, it is there. It is with the department. I spoke with them on it. This guidebook that he spoke about, I requested it and didn't get it. It goes on and on. That email that they put up, I sent it from my iPhone, and then when I went home at night, I resent it under the correct emails. So not only are they standing here backing each other up with a lot of talk, they're not producing any documentation to support their claim, which is it's a technique they use all the time.
Mr. Highland.
Ms. Datesh, name another document you did not receive.
Many.
One that's concrete, that we can see in our package.
I asked for the budget for the street artists from 2013 to 2014. I did not get it. And if he claims that I received it, let's see the email where proving that.
Okay, hold on. Mr. Lazar, can you answer that specific question? Can you show us where in the package that is?
Which one was it? That was the, for 2013, the budget? Is that it?
It would be helpful to know which number it was on the complaint, because we have it all enumerated.
What was the date, Ms. Datish, of that one?
Yeah, what's the date of it?
It was the April 25th, 2014 IDR.
Number 6, Howard.
Dear Ms. Datish, please see attached PDF of Arts Commission's budgets, which includes the Street Arts Program budget for fiscal years 2012-13 and 2013-14. And then we go on to answer her questions, how the budget was calculated, and the Arts Commission has no records or documents in response to your request for the dates and times any employee of the SFAC went to the mayor to request money to cover any deficits during both those years, unquote. Please see the attached PDF of the two budgets, which is in response to your request for, quote, the money amount that the mayor allocated to Street Artist budget for both years, unquote. The
Page
agenda.
421 of the packet.
Here, I'll
Those
put
are
it up
online,
for you.
yeah.
421 at the bottom?
Yeah, they're at the bottom.
Okay.
I didn't get it.
And scroll way down.
Well, it never got returned to us.
Hold on one second.
Can you see that okay?
That is on page 421 of
Right.
my packet.
And I also didn't understand the phrase "when both burgers were calculated." I thought that was weird and didn't make any sense to me. But tell me about burgers another time.
It's because I work in the street and I was sending them from my iPhone so that I would go home at night and resend it and make sure that it was the correct information. So you asked for more specific information. His technique of forgetting to send PDF
Ms.
attachment.
Datish, we're looking at page 421. It looks like they've answered this particular request.
I didn't get it. It wasn't sent to me. This is my first time of seeing it.
pdatish@aol.com.
I didn't get it.
Well, it was sent to you.
I didn't get it.
Okay. Mr. Lazar, please.
Sir.
You did mention that there was one, when you provided your first testimony, that there was one incident in which you did not respond.
I did. That was, it was an IDR, May 20th IDR, that's listed there. And I was out of the office on May 19th to 26th due to a medical emergency. Excuse me. And however, I had an out-of-office email response that was put in place by my assistant, Ms. Licouris, referring requesters to Ms. Licouris. And I returned on May 27th, and I responded that day. I also want to mention that May 24th and through to the 26th was Memorial Day weekend. So I don't feel I should have been held accountable for that time. That's Saturday, Sunday, and the 26th, which was a Monday. So therefore,
thank you.
I responded on the 27th.
Thank you.
Yeah.
All right. I think it's. I think we've heard enough right now. So we have a motion before us. We've heard some additional testimony or responses to our question. Members? We could hear public, or if the members have anything else regarding the motion or ideas. Member Rummold.
I think I am going to vote no on whatever motion is proposed in the absence of some type of finding of fact. Like I think what the person from the Arts Commission said is valuable and right. There's a huge quantity of information here, and unless we can point or, unless the complainant helps us point to specific documents that are absent or specific responses that were delayed, I think there's a lot. There's a lot for us to process, and I think unless we're going to specifically enumerate the violations, I don't think it's valuable for anybody. I don't think it's fair for the complainant. I don't think it's fair for the respondents, and I think it's kind of it's us throwing darts in the dark, basically with a blindfold on at a target we can't really see.
Thank you. Vice Chair Hyland.
In light of the ensuing discussion, I would tend to agree with Member Rummold. And I think, Ms. Dachis, this might serve as a primer for you in future. When you come before us, bring us a concrete list. Because I'm sorry, a lot of the time, your time that you spend on the microphone is full of invective for the Arts Commission. That doesn't help them or us get to the bottom of it. Maybe in future IDRs and in future times you appear ahead of us, that would be really helpful. Give it to us clearly, short, concisely, what it is that you still need. We've asked you that several different ways. We've looked for it several different ways, and we can't find anything.
Okay, let me just address the last one. I accept your thing, but you got to understand that I don't even bother to banter with these people.
No, I understand, and this is something that we're going to, we hope that the Arts Commission will find another, custodian of records or someone that deals with sunshine, because that maybe it's a two-way street here. I don't know, but we're looking at the specifics of this case, and we're struggling to find.
I will give you specific instances.
You've had your chance. I think we've heard.
He
enough.
stood
Thank
up
you. Thank you.
here.
Thank you, Ms. Stadish.
That was a late response.
Excuse me.
There was no email redirect, and he cannot provide evidence
Ms.
of his
Stadish,
testimony.
We have to move on.
Be happy to. I dumped their permit. I don't even work in this.
Okay.
Because the retaliation.
We have a motion on the floor. I must say I'm starting to feel much the same as my colleagues. There's a great deal of information here. I would hope that Ms. Stadish would look at what's been provided to the task force and pinpoint what's missing. But at this time, I'd like to hear from members of the public.
I'm Patrick Bennett Shaw. I'm as equally frustrated by this as you are. I think that Member Hyland is correct that Ms. Stadish needs to provide an explicit list of what is still outstanding. But with that said, I would like to note with interest that on this portion of the complaint dealing with statements of incompatible activities, she should have been directed, if she was not, to the Ethics Commission website where they are all collectively posted. The Arts Commission is correct. They do not distribute that document other than to their employees annually. There's a requirement by ethics that each city department and each board and commission, subject to a statement of incompatible activities, needs to notify every one of their employees and or every member of the commission where the SIA is posted, or alternatively, to give them hard copies, or there's a third method in which the departments can satisfy the ethics requirement to provide that annual notification. Of great interest, when I put in a public records request to the clerk of the Board of Supervisors to obtain the annual notification to the Sunshine Task Force about when you had received notification of your annual requirement to review the SIA annually, the clerk of the board's office provided me with an April 1 deadline for 2013, which is the annual deadline. in which each city department has to comply by April 1st. Guess what? This year, the clerk of the board forgot to notify you guys of your requirement until after I placed a records request. And you weren't notified of that annual requirement until June, which means, by extension, that the Arts Commission should have provided Ms. Dadish with a list or each annual email notification to the employees of the Arts Commission that they had to comply with the SIA. It appears that portion of her records request involving the SIAs clearly was not complied with or even offered or even mentioned by the Arts Commission, that she could have been provided those documents.
Thank you. Is there additional public comment on the motion? Okay, the matter's back with the task force. Vice Chair Hyland?
Can I amend my motion? And can I do it in an expeditious manner so as to move forward?
Yes. Expeditious is good.
I like the recent public comment there, and we heard Howard Lazar telling us how, he's not required to, but the department holds it. But a true custodian of records would have acted under 6720E and provided that information to Ms. Dadish. That did not happen. So I think that is a more 6720C, I should say. Custodian of public records shall assist the requester in identifying the existence, form, and nature of any records or information. That might be more, and it kind of goes to having someone on point at the Arts Commission other than Howard Lazar to do this. He's obviously a very busy man, and I think there should be somebody else doing this and doing it more completely for other sunshine requests. So,
Member Pilpel.
I'll second a motion on 21C, although even if it fails, I would still like to vote on 21B. I still feel that there's enough there, at least for me. And if it fails, it fails, but I'm happy to also second a motion on 21C.
I have a feeling that it's going to fail.
I do, too.
And I'm trying to...
All right. Fine. Be that as it may, why don't we withdraw the 21B and instead substitute 21C?
20C, 6720C.
21C.
Are there any questions about the new motion? Any comments on it?
I think it's 6720C, isn't it?
What is it? Well,
Yeah,
I'm
what
sorry.
is it?
How do I request an opportunity to speak? By raising my hand?
Yes.
Okay.
I see hands, yes.
Chair Washburn.
Okay.
Member Rummel.
So, can you explain, Member Highland, what exactly the violation would be and where in the documents produced there was, a failure to comply with that provision?
So let me answer that more completely. So what we're going to do is I was going to withdraw the first motion. Member Pilpel would also withdraw. There's a provision of Sunshine that the custodian of records or the person that's answering it helps them find that information if they don't have it, or explains where they can get it. I'm seeing a clear violation in that case that didn't happen, and as Mr. Lazar said, he thought she meant Form 700s, which she didn't. He was clearly after SIA. He could have told her what the department policy was on that and where to find those documents. That did not happen. That's about as cut and dry as I can see.
Member David.
I just want to know, are we certain that these documents, these SIA documents, exist and they weren't provided?
They're on the Ethics Commission website.
Member Pilpel.
So
I'm saying specifically Mr. Lazar's SIA records.
Okay, so to try to clear this part up, the statement of economic interest, the Form 700, that's a requirement that goes way back. The department should have records for Mr. Lazar either back to...
No, that's what I'm trying to explain to you twice now.
Just a minute.
I'm sorry.
This is the statement of economic interest. The department should either have them going back to the beginning with Mr. Lazar, or at least for whatever their retention period is for those records. Okay. The Statement of Incompatible Activities, the SIA, is a new requirement. There is a document that is the departmental SIA that's either on their department website or on the ethics website, and there's supposed to be a memo distributing that to all employees annually. The SIA itself should have been provided. The memo memorializing distribution could have been and probably should have been provided, and any advance written determination request and response, which I think were provided, were all within the scope of an SIA request. It's complicated, and just because Ms. Datesh doesn't know all the right terms doesn't mean that the department is not on the hook for providing as much as is reasonable to respond to that request. Does that help? Probably not. All right, I tried.
Vice Chair Hyland.
So I'd like to withdraw my first motion
I concur.
and propose a second motion, violation of 6721C.
And do I have a second?
Yes.
All right. Any discussion, questions from Member Fisher?
Going through all of the ODs that we've done that those of us have done over the past couple of years, I'm really torn on this one because while we've had Ms. Datesh in here many times, and many times her arguments have been very persuasive, and we have ruled in your favor, and we've made some incremental positive changes with the Arts Commission, I just don't think this one was that persuasive. I think the last one we had with you was, and I voted for that. I just don't think this one is that persuasive, no matter what you call it at this point. But by all means, don't give up. We're here every month.
If I could, I think that I've been persuaded that Howard Lazar in particular could have been more helpful in directing Ms. Datesh to some of the information that she needed. I don't see, and I see this as indicative of a much larger problem that we were mentioning earlier, having a process in place that will enable people to get information from the Arts Commission in an expeditious manner and make sure that people are helped appropriately and so forth. And so by finding a violation here and forwarding this to the EOT, perhaps we could help set up something, and it's urgent because of Ms. Patterson's maternity leave coming up, that something be put into place to ensure that record requests are answered thoroughly and promptly and so forth. So that's what I'm thinking.
Public comment on the new motion on the floor.
Well, there will be, yes. I'm just wondering, is there anything else from members? Okay, at this point, I'd like to open this up for public comment.
So I find it extremely disingenuous of Member Fisher. I know for a fact that April 1 is a deadline set in stone by the Ethics Commission. Ignoring the Ethics Commission's April 1 deadline would be analogous to ignoring the august advice coming out of deputy city attorneys. I thought the charge was that you shall not ignore advice coming out of the deputy city attorneys. By the same token, an Ethics Commission regulation that specifies an April 1 deadline to notify members of each city department and each board and commission and task force who have to comply with SIAs is an immutable deadline. Mr. Lazar And the current custodian of records should know that. In part because out of the hundreds and hundreds of city employees who file Form 700 Statement of Economic Interest that are not filed with the Ethics Commission, but are instead filed at the department level, they have very specific requirements about filing those Form 700s and sending out the notifications annually to comply with the April 1 deadlines. That's something that any custodian of record, any public information officer, or any program officer like Mr. Lazar should be well versed in, and there is simply no excuse that that information was not shared voluntarily with Ms. Dadish. You need to unanimously, Ms. Fisher, find the violation that Member Highland has proposed in this new motion. You really need to get this done. You really need to send a signal to the Arts Commission that it's long past time, since they are one of the city departments that is so frequently violative of the Sunshine Ordinance, that they need to get with the program. That's why the voters passed the Sunshine Ordinance. Thank you.
Is there additional public comment on the motion? Okay, seeing none, Mr. Young, would you call the roll on this, please?
On a motion to find the Arts Commission violation of 67.21C for failure to assist in providing records. On that motion, Member Rummold.
No.
Rummold, no. Member Winston.
No.
Winston, no. Member Pilpil.
Yes.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
No.
David, no. Member Fisher.
No.
Fisher, no. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye.
No, it didn't.
The motion fails for, by a vote of 5 to 4, the motion fails.
Thank you. At this time, would you please call the next item on the agenda?
Before we move forward, even though we are not finding a violation, and it seems like there isn't going to be another motion, I'm certainly willing to calendar at EOT a discussion of the public records policies and procedures at the Arts Commission. It sounds like that's probably what we wanted anyway, and maybe that's the best way forward, even in the absence of a violation.
I'll make a note that we haven't settled on the membership of the committees yet, so, but I'll make a note.
Assuming that I have something to do with EOT. But, okay. Unless there's objection from other members. Right.
All right, Member Young, or excuse me. It isn't even that late yet.
Item number 6, file number 14043, file complaint by Emmanuel Kurkolas against Lynn Tomioka and Brienda Bernolis, San Francisco Police Department, for allegedly violating Sunshine Ordinance Section 67.21 and Government Code Section 6250 for failure to adequately respond to a request for information.
Okay, at this time, but we have to determine jurisdiction. I don't believe it's been contested. Do I hear a motion to find jurisdiction in this matter?
So moved.
Chair Washburn, we've got some discussion over here.
Excuse me. We need some quiet here. Thank you. Is there a second to find jurisdiction?
Second.
Is there any public comment on the motion to find jurisdiction on this matter?
I will make this very brief. I support the motion to find jurisdiction, and because this meeting is running so late, I would like to ask you to expedite this hearing and move things along to get it back on time schedule. Thank you.
Thank you. Is there additional public comment? If we could pass this motion without objection? Seeing none? Okay. I see both parties here, and as with the previous hearings, the complainant, well, this time you have 5 minutes to present your complaint, and then there'll be opportunities for anyone to offer facts and evidence in support of you. Then we'll hear from the respondent for 5 minutes, and then questions back and forth. Mr. Korkulis?
Yeah.
Okay.
Yes. Madam Chairwoman, members of the committee, my name is Emmanuel Korkulis, and I'm sorry. Basically, I'm requesting a report filed against me with the San Francisco Police Department and an emergency protective order issued. Actually, there were 2 reports filed, and I found out that these reports were filed on June 12th, and the emergency protective order granted until June 19th, I believe, for 7 days. I found out about that on August 6, 2013. I was never served, but I found out about that at the Labor Commission hearing where the emergency protective order was used against me on a hearing for retaliatory termination of employment. At that time, I found out that there was a report number 130-485-370 filed by Mr. Karagiorgos, and on the narrative it says that my ex-wife was with him when a psychologist approached them in the middle of the street and advised them that I was mentally unstable and they should be concerned for their safety. They had no information for the psychologist. However, the San Francisco Police Department took this report and obtained to Commissioner Abidanti and obtained an emergency protective order. When I found out about that, I went and requested a copy of the emergency protective order orally, and a copy of the report 130-485-370, which I was granted. At that point, I filed a report with the San Francisco Police Department, report number 130-717-101, that Mr. Kolek has wrongly included as a report that was used to obtain an emergency protective order. No, sir. That is a report that I filed requesting investigation of report 130-485-370 and report number 130-485-386, which was also used to obtain another emergency protective order by my ex-wife. Now, mind you, I'm the victim of a violent crime. I was shot in my chest trying to protect her life. But that's neither here nor there. The fact remains that upon request of the public records of report 386, I was met with total indifference from the San Francisco Police Department. They flat out refused to give me that report, saying that it is confidential and an attorney has to subpoena it. On my request for that from the San Francisco Police Department, I have a response here from Maureen Confrey at the Legal Division stating that it could not be released to me. That was the only report that I had requested under the Sunshine Ordinance, 130-485-386. Instead, Assistant Chief Linta Mioka sent me report 130-717-101, which I had filed, and this time it arrived with reductions saying that it was whatever. In the meantime, I do have an unredacted copy that was approved by the San Francisco Police Department on January 8th, 2014. So how could that be that 3-4 months later, this report is not available to me, even though I have filed it and it is redacted? On finding out about the emergency protective order associated with report 130-485-386, I requested a copy of the emergency protective order orally. And I did receive one, except that the protected person is redacted. The address that I'm supposed to stay away from is redacted. And the reason that this emergency protective order was granted was redacted. I still request 130-485-386 under the Sunshine Ordinance, believing that my civil rights are being violated, of being accused of something that I don't know what, and the San Francisco Police Department not trying to assist me whatsoever, giving me the runaround, and especially with Assistant Chief Lynn Tamioka sending me the wrong report, redacting a report that I have written, and mentioning on my letter, on the letter that was sent to me, that the report that I requested on March 13, with the timestamp from the San Francisco Police Department when they received it, was not going to be given to me. I never requested 101. They sent me the wrong reports, they've given me the runaround, and I have not been able to find any succor in this.
Sir, you'll have some additional time and we'll have questions for you. Thank you so much.
Thank you.
Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent, you have 5 minutes.
Yes, I'm Sergeant Anthony Pedroza from Police Legal, San Francisco Police Department. I'm here representing Deputy Chief Tamioka on this complaint. A lot of the facts I think I'll have for you about the case, I think you already know. Obviously, especially making this a domestic violence related report, you guys have heard many times before government codes that prohibit the release of police reports as public documents, so I won't even get into that, and if there's any questions, I'll answer them, though. I just wanted to comment about the just a couple of things that Mr. Korkulis brought up. He's saying that upon request of the police report, he was met with total indifference. We responded on the same day to his written request for the police report. Not only that, in the response, we attach documents that can help him try and get the police report from records if he so tries to do so. So I just wouldn't call that total indifference in any way. The emergency protective order was withheld for obvious reasons. The most obvious is Section 841.5 of the California Penal Code. The emergency protective order, in case members don't know the policy, San Francisco police officers do not decide that an emergency protective order is granted. A Superior Court judge who does. In this case, it was Commissioner Abinanti, Abinanti, who granted the emergency protective order. Mr. Korkulis mentioned to you that he received the emergency protective order, which was requested only verbally, and that he received it redacted with the name of the complaining party taken out and the address. That comes straight from reading Section 841.5 of the California Penal Code, that the names and address of crime victims cannot be included when releasing documents to a person who is a possible defendant or a suspect in the matter. We just have more backup materials that, that includes something as minor as shoplifting. This, we have actually department bulletins and California state law that says 293 PC of the California Penal Code protects the releasing, or actually stops law enforcement officers from releasing incidents in many types of what are deemed confidential reports by the state of California. In this case specifically, it was a domestic violence report. So that would that's my only response. I believe the complaint and Mr. Young, correct me if I'm wrong, is for not providing the materials in a timely manner. The EPO was only requested verbally, and we responded within 9 days of the EPO request with a redacted EPO. The report was responded to within hours, saying that pursuant to Government Code 6254F, 6255, and obviously, like I've explained, Penal Code 841.5, that those weren't going to be released to the, and I know he's a complainant, but because it's the domestic violence, but I keep referring to him as defendant, I apologize for that, but to, in this matter, the defendant in a domestic violence case. So I believe that's what the complaint was too. We responded timely to the request, and even though we weren't asked for the EPO, we were asked for it only verbally, we responded it within 9 days and provided that document. Thanks.
Thank you.
Sure.
Members of the task force, do you have any? Oh, I'm sorry. Is there anyone here to offer facts and evidence in support of the respondent? You see none. The matter is with the task force for. Member Winston, do you have questions?
Sergeant, I have two questions regarding this. First off, regarding the original incident in question,
yes.
Was Mr. Korkulis ever charged?
He was not, and if you'd like follow-up on that, because I think I know where your question's going, it doesn't matter. The Penal Code protects it forever. But I don't believe he was charged, but it wouldn't matter one way or another.
Okay. Sergeant, sir, could you give me a moment? Sergeant, was the narrative of the incident cited in the emergency protective order redacted?
Yeah. So part of the basic how it states is, and I can read it to you verbatim. In the emergency protective order, basically what the judge hears, it's a condensed version, and by condensed I mean very condensed, very vague. The events that cause the protected person to fear immediate or present danger of domestic violence, child abuse, elder dependent, everything else. There's a spot on the emergency protective order for only 3 or 4 lines of explanation. That's because obviously it's given to a superior court judge. They're the one granting it. They already have the information. So on the order, it doesn't go, nothing's recorded or anything. So that was, I believe in Mr. Cor.
Excuse me. Could members of the
Mr. Korkulis,
public, please be quiet. Okay.
Can I respond to this? But that was taken out by us, by our department, and I believe it was included a second time around when he made a different petition to the city attorney's office. It was included, but that wasn't released by our department.
Okay. Could you point me to anything in 841.5 that forbids the redaction that allows the redaction of the narrative of the incident rather than the name or address?
No, but remember, the 841.5 speaks to police reports and not emergency protective orders in general.
Understood. So 6254F is the cause for redacting that information, the narrative?
It would fall under both, and we have department bulletins and state law that was taken out. It would essentially be the same as putting a narrative. Information from that explanation on the EPO comes straight from the police report narrative.
So my concern here is that I see the need for redacting information about names and addresses, but at the same time, the nature of the incident in question, I've reviewed quite a few police reports in my time. That information is, I understand, date, time, nature of the incident. That's public information, no matter what sort of incident it is, even if it's a domestic violence, even if it's a sexual assault. And if the specific number of the police report is provided and requested, that information, from my understanding of police procedure, is typically public, even if it's released in a blotter format or so.
Okay. In my understanding, any release of a domestic violence report or current investigation is done through the officer in charge of the Special Victims Unit, and the emergency protective order was requested from that unit. It was turned over to us like this, and this is how we sent it out.
Understood. Thank you.
Yeah. It's not something, we didn't redact it, if that's the question.
Member Pilpel?
So I'm looking at the March 13th response.
Sorry.
Yeah,
okay.
To Sergeant Pedrosa.
Sure.
The response from Ms. Conifrey?
Yes.
Includes the reports you're requesting are exempt from public disclosure, including a reference to 6255. Now, under the Sunshine Ordinance, the city is not allowed to assert 6255 or any similar basis as a basis for nondisclosure. Can you speak to why that's included in the response? Because that's yelling violation out to me, right?
No, I can't. This is sent out as a response by the person responsible for PRAs, and that's how it was sent out.
Okay.
It's still, the 6254F is in there, and the 841.5 is...
I got those. I'm with that part of it. Okay, so you can't answer that part. As to the original request from Mr. Korkulis, for the report number 386, I'm a little confused about the difference between a police report and an emergency protective order. I'm not sure if I need to know that right this moment, but can you tell me why the report ending in 386 couldn't be provided even in a redacted format?
No, it was a domestic violence report also, as he referred.
Okay, so...
In one way or another, it would still be exempt under 6254F was our response on that.
Well, then maybe I'm back to where Member Winston was a moment ago.
Mm-hmm.
Generally speaking, maybe I need to step back and have a better understanding. Generally speaking, a police incident report, and I guess these are all incident reports, correct? Are they...
The ones of those numbers are.
Okay.
Yes.
I mean, as opposed to a CAD thing, which I understand is something different. Right.
Mm-hmm.
So is a police incident report subject to public disclosure generally?
No.
No. No?
Right? 60...
Tell me about it. I'd like to hear.
Report you're requesting are exempt from public disclosure pursuant to 6254F. That was a response that he got.
Right. But I was asking, generally speaking, a police incident report, I call and say, my bike got stolen or somebody threw a rock through my house. Somebody takes a report.
If you're the victim of it, then you have the rights to it.
Okay.
Mm-hmm. Domestic violence reports.
But other than that, if someone tells me about a report across town?
Okay, I'm sorry, not through a PRA. Not through a PRA.
Well, can you explain this? Because I'm sorry.
Yeah,
maybe
police reports
are
released
works.
through PRAs.
Are or are
not?
What are
released
they?
through
Are they
a public records report? They're not released through public records. Our records division is who releases police reports.
Are they public records?
Are what?
Are reports of police incidents public records?
Well, police reports, what kind of police reports? It depends.
Incident reports.
Yeah, thank you. Yes, police incident reports. Are they public records?
They can't be requested under public records.
No,
that's what
I'm
I'm
asking,
saying.
is it a public record? I'm not yet asking if they're subject to disclosure. I'm asking, is it a public record?
I don't understand what you're asking. This is a domestic violence incident.
I'll defer to Member
They can't be released.
Sergeant,
yes.
We're asking a basic question here. Does the San Francisco Police Department, so an incident report is filed, contact with police is taken, an arrest is made, an arrest is not made. The officer writes up a report, it's given an incident report number from the CAD, right?
Mm-hmm.
He writes up that report, he files it. Does the San Francisco Police Department view that incident report, any incident report generated, whether it's domestic violence, ag assault, battery, loitering, do they view that, and do they view police
I guess
generally?
I guess the short answer is no, then.
So
if
these
you're
are
asking
not-
it how you're asking it.
I'm asking whether incident reports writ
Because
large
it would depend
are
on the
viewed.
type of incident report. That could depend also.
So the department defaults to no, they're not public records unless there's some sort of cause given to release.
I guess you can say that because they're not released as public records. They're referred to our records room to determine if you're a victim or not. What happens after that with them is not a, you can pull your own police report.
If
I think
as a
specifically.
member, let me just ask you this: as a member of the press,
yes.
If there's an incident, there's a shooting down on, there's a shooting down at the, down on, Third and Revere, right?
Okay.
And I say, okay, well, I have the date and the time of the incident, and someone gives me the incident number. If I file a Public Records Act request for that incident report, if charges have been filed or not, regardless of that, if I file a Public Records Act, is that document deemed
And you're
necessary?
saying if you're a member of the press?
I'm a member
See,
of anything.
these are different
So here, let me just put it like
scenarios.
this. If I live on that corner and I file a Public Records Act request, will I be able to get that document?
So in that case, no, if you live there.
Thank you.
I think that's what you're asking, I believe. And it depends if the case is adjudicated, if it's not, there's other factors.
Can I follow up?
Yes, Member Pilpel, please.
And just to follow up on that point, does the department have policies and procedures that explain when you can, when you can't?
Yes, release of police reports. Yes, of course we do. I believe it's under section 3.19 of our Department General Orders state the releasing and not releasing a police report. What can be released, what can be released, what can't be released, but definitely one of the ones that can't is the incident we're talking about here at hand today. It's not public record.
It would help if we had had that as part of our information, because most of us, Member Winston is certainly more familiar with this. Most of the rest of us, I think, hopefully don't get arrested all the time. And
yeah, I'm thinking of the incident that we're talking about today.
But I don't think we're generally familiar with how police incident reports are handled. So I'm certainly trying to understand.
Okay.
I guess I'm still struck that there ought to be a way to release the incident report with redactions so that the names of witnesses or whatever are not provided, but the substance of the incident is provided. And I'm not sure I'm understanding.
Yeah, there's certain information that can be given out on certain situations, but the short answer is that no, they're not public record.
Just for clarification, General Order 3.16?
Don't quote me, 3.09 or 3.19.
All right. Is that the release of public information?
Release of police reports.
Okay.
Yeah, release of police reports. And that's the section that the first line of the section refers back to 6254F.
So I'm looking at 6254F right now. It's in our packet at page 690. Can you tell us on the specific facts of this incident how in 6254F that leads you to nondisclosure?
Okay, the non-disclosure of the police report is something totally different than the non-disclosure of a domestic violence incident. That is part of it. That police reports aren't released as part of a public record, and then added to that line in the original letter that Ms. Conifrey sent, Section 841.5 protects also, and our department bulletins and our Department General Orders protect the releasing of police reports to possible suspects in the incident.
Again, 841.5 seems to preclude disclosure of names and addresses. I'm trying to find in 6254F, if you can walk through it with us, how you get to non-disclosure of the report. You may have a basis for it in here, but that wasn't explained.
I mean, you can show me the section, and I can read it verbatim. I mean,
it's right here.
But that's how police reports. Police report is denied under that.
Right. Can you tell us how? Because I'm not. There's some stuff that's italicized here.
Okay.
Can you walk us through how you get to that conclusion from this? It's not obvious to me. Is it obvious to others? Am I wasting time?
No.
Okay.
I see here in the Department's General Order 3.16, which is issued, by the way,
3.16?
16. It's issued 20 years ago, which may or may not have any bearing on the relevance, but whether it needs to be updated. But let's see. I'm looking at Section 2, subsections A6. The name of any victim of a sexual assault who specifically requests that it not be disclosed be withheld. And I see number 3, information that would endanger the successful completion of an investigation, but only when the prospect of enforcement proceedings is concrete and definite. Now, this case has not been, Mr. Korkulis had not been charged in that case, correct?
I have no idea. It doesn't make a difference. And the 6254F part of the section is investigatory. My apologies. If a report is considered in investigative stages, which this was at the time the request was made, then it's not released pursuant to a public records request.
Okay, but go to the however language in there. However, agencies shall disclose the names and addresses of the person involved in or witnesses other than
Okay, and we can't do that because of 841.5 PC.
Right, but then there's the rest of that. So after the names and addresses of persons involved.
Yes. And
The
state law.
incident, the description of any property involved, the date, time,
Yes.
location of the incident, all diagrams, statements of the parties involved
Yes.
in the incident, the statement of all witnesses other than the confidential informants to the victims of the incident.
Penal Code 293 PC and Penal Code 841.5 PC, the California Penal Code, prohibit the release of any information regarding a domestic violence incident. Domestic violence victims need obvious rights. The person suspect in it is not. It's not provided. It's not provided. The officer in charge, captain position, commissioned officer of the police department, who also, it's proof by that, felt the need to redact even a narrative portion at first of the emergency protective order. That's protected under our department bulletin, which I have a copy of here, which is crime victim confidentiality, and which is right out of 293 PC and 841.5 PC. I guess the reason, and I'm not trying to sound condescending about it, but it's our rules governing release of information and reports regarding domestic violence incidents is so serious and so obvious to police officers that nobody gets anything, that I guess maybe I'm having a hard time kind of explaining that part.
Yes.
But the 6254 investigatory, and why Ms. Conifrey, I can assume, added an 841 into there and 841.5 into that section is because the name also has to be protected.
We understand the name
Yeah.
needs to be protected, but what we're... Mark, go ahead. I'm sorry.
So, I think you're right. I think the statute definitely protects the name, definitely protects the address. But there's a big chunk in here that says, a description of the incident has to be disclosed. There's another part of the statute that says, unless the disclosure would endanger the safety of a witness or other person involved in the investigation.
And it does.
Which you could certainly, say that that's a basis for.
Automatically in domestic violence incidents, it does.
Well, I'm not so sure that automatically. If there was an officer who was involved in the investigation, who had filed something and was a part of this complaint, that would be something that I could look at and say, this person was involved. They've assessed the facts based on their experience and their assessment of the facts. I'm inclined to defer to that.
And an officer in charge of a unit is the only person that can do that. And the precedence is I'm trying to think of it, trying to put my head totally around it. But the fact is that a victim in a domestic violence incident, it has to be protected. It says, however, and it gives an option, and the view of the state is
that's not optional.
The view of the
It's
state is
shall.
there's not.
The language of the statute is shall make it public. So unless the disclosure would endanger the life
and that's what it does. And from what I've been reading from this incident, it does. A Superior Court judge issued an emergency protective order, and like I said, I don't know specifics about the case or the specifics about the first report that was made, but if a Superior Court judge is issuing a protective order, the safety of the victim is firsthand for our department, and that's the view of the department in general.
So, can I jump in for a second?
Member Pilpel.
So, if I may, I think the explanation you're now giving us may well be appropriate, but it's not in the letter. And I think what's important is to not just give a blanket, no, we don't ever, but if you're saying that a specific captain made a determination and that a judge or a court commissioner issued an order, and on that basis, you believe that disclosure would endanger the safety.
That wasn't known in the first letter. The first letter from Ms. Conifrey was only for the police report.
Well, again, I think you have to have a basis, and you need to explain the basis in the letter to either. If you're not going to release information, you have to explain why on the specific facts and circumstances, not on some broad, generally we never, ever, but. It's got to be specific to the facts. And I'm still not happy about seeing 6255 in a letter because the city is specifically not allowed to assert 6255. That's in the plain language of the Sunshine Ordinance. Thank you for letting me defer a minute.
Thank you. Other members? Member David?
I'm trying to look for the letters from Ms. Conifrey, but when I read them the first time, I feel like that they specifically called out the legal reason, the legal number, I'm sorry, it's getting late, I apologize, for why they're not disclosing. So I feel like that's part of the Sunshine Ordinance, is that if you do not disclose, you have to give the legal reason to do so. And it seems that it wasn't just in all incidents, we don't do this. It seemed like they specifically called out the legal reasons for not doing it. Now, we as a task force might disagree with those reasons, but I do think that they didn't just give a broad, I disagree with the view that they gave a broad generalization. I think that the letter specifically called out the ordinances as to why they were not disclosing. Yeah.
So to respond to that, if I could, I fully agree with you that they cited the statute, the part of the statute, but then the statute itself requires, the type of particularized assessment of the facts that we're asking for, and that may in fact exist. I'm not suggesting that, this couldn't endanger the life of someone or the safety of a witness. It certainly could, but it requires some type of, it requires more than just a blanket statement that says, no, this statute protects the information.
I think, like I said, I can't speak for Ms. Conifrey again, but I think her saying, in her defense, she's not with our department anymore, but she goes on to say that she doesn't say they can't be disclosed, but they're not available for public disclosure. And I think by providing last time I was here for the compliance hearing, it was about trying to provide the public with more, by attaching a request form, for the complainant in this matter's convenience, I think she did that. But if the sections need to be spelled out, they can be spelled out more. I thought she did, but if not, then
I don't think it's a question. I think she cited the statute correctly, and I think that's all right. It's a question of the factual assessment that went into deciding that the statute applied that we're looking for. We're not saying it's certainly absent from this, but we're not saying it doesn't exist and couldn't be provided.
Right, I think that I'm looking at the letter from March 13th, and had I received this, I would be extraordinarily confused. It seems like there's information available, but it's being withheld for some reason or other, and here's a form to go ask for it. It's not helpful. Yeah, it's mystifying.
I think Kafka's is actually appropriate. And frankly, I think in my work, I've seen 6254F used on routine police reports for violent incidents that have been charged in court, and I have obtained the documentation otherwise. So when I see 6254F, regardless of whether it's DV or any other sort of incident, it raises a bit of a question in my head because I've seen it. It's a very broad exemption. California is one of the states that does have one of the broader exemptions for investigatory files, and quite frankly, I've seen it abused.
Are there any other questions at this time? All right. At this time, the respondent, you have 3 minutes for additional remarks or rebuttal.
No, the only thing I would say to that is I think if I got my timeline correct, the letter was sent on March 13th of 2014. I know that's something different. No, I think that's it. We let the complainant know. Like I said, in this case, I don't want to hamper the domestic violence thing, but I think that's one of the reasons why it was also that we responded so quickly on it. We let the complainant know how to get a copy of the report if he could. There's other means of doing so. We referred him to the way he could get it. The emergency protective order was at first provided redacted, was eventually provided unredacted also. that's another thing. I mean, the department's view is that in this incident, reading it, and in any domestic violence or anything protected under 293 PC, that the suspect, potential suspect, or defendant in the case is not going to receive that. And that part I think is simple enough. So.
Thank you.
Sure.
And the complainant now has 3 minutes. I'm sorry, 3 minutes to offer a rebuttal or any
Madam
additional thing.
Chairwoman, members, first off, my request for records from the San Francisco Police Department has been altered. It was dated January 8th, which I received a letter from it, a report. Now, I received this in the mail. They changed the date from 0108 to 0115. They changed the requested report number to a different report. Okay? I have a letter here also from the San Francisco Police Department saying that the emergency protective order with fewer reductions, at least it's letting me know why it was issued. And to answer to Member Winston's, as far as members of the press are concerned, according to Ms. Paula Jesson, the custodian of records, I have a letter at home. I thought that it would be part of the record here. It says that the member of the press can request it. Okay? Freedom of Information Act. It's a federal law. I should be able to know what I'm being accused of. Okay? Especially when this report is associated with another report, and you can see the narrative. All I was requesting was the report 386. I was requesting the narrative just to prove that just like report 370 is false. I mean, which psychologist would approach somebody in the middle of the street not knowing who they are and tell them that I'm dangerous or that, things like that. Now, according to this, this is from Michelle Dawson, Assistant District Attorney at the Hall of Justice, and it says that report 370 was dated 6/1/2013. Report 386 was dated 4/20/2013, and my report referring to the previous reports was dated 6/12 as far as when the incident occurred. Now, I really don't understand how it is possible to be accused of something and not know what you're being accused of. How are you going to fight that? The police department did investigate that. According to Ms. Dawson here, it says no charges filed because basically the emergency protective order is granted in order to protect the parties so they can go obtain a restraining order. To obtain an emergency protective order, there is no burden of proof. To obtain a restraining order, there is burden of proof. Therefore, and the only reason that they did that was, just to use the San Francisco Police Department as their whipping boy against me on the Labor Commission hearing, not to mention the fact that she cleaned me out of $75,000 and I had to go on general assistance for a period of time.
Thank you. Mr. Young, I don't think the other members have seen it. Okay, the matter is with the task force.
Can I ask a question?
Member Pilpel.
To Deputy City Attorney Cola. I'm inclined to find a violation of 67.24G over that 6255 assertion and possibly 67.27, but without getting into the police particulars about incident reports, and I'm not even sure if 67.21D applies. I think it's probably not on point. It's more a 6254F issue and interpretation of all of this stuff. What potential violations would you suggest based on that line of thinking? I mean, I think in what we were discussing, it may be that that there is justification for withholding, but it seems that there was insufficient explanation in their letter, and so I'm struggling with that. And I think that's where Member Romold was going as well.
You said initially you were thinking 6724? What section?
67.24G and possibly 67.27.
No, sir, it's the matters with the task force. If you would be seated, please.
I mean, given the oral testimony that was given here today, 6724G seems somewhat appropriate if that's what the task force wanted to rule on.
Clarify what that paragraph is.
We'll explain in a moment.
While he's looking that up, I'll read that for members of the public. Neither the city nor any office, employee, or agent thereof may assert California Public Records Act, Section 6255, or any similar provision as the basis for withholding any documents or information requested under this ordinance.
And potentially 6727D.
B or D?
D as in dog.
D, okay.
You want to read that?
When a record being requested contains information, most of which is exempt from disclosure under the California Public Records Act in this article, the custodian shall inform the requester of the nature and extent of the non-exempt information and suggest alternative sources of the information requested if available.
Good
Yes.
stuff. All right.
Do I hear a motion?
I guess I'll so move.
Second.
We're moving to find a violation of 67.
That'd be 6724G
G, okay.
and 67.27D as in dog.
Okay.
Let's be. I'm good with the sections. I'm just thinking now about who's the actor here.
Tomioka.
Well, one sec. I mean, that is potentially the answer, but I'm trying to think about how we get there. We could certainly name Ms. Conifrey. It was her letter. She's no longer with the department, so where's that going to go? Sergeant Pedrosa's a fine guy, but Deputy Chief Tomioka is certainly a person, but it wasn't her letter, so I'm just struggling with what we do. I clearly think there's a violation, but I want to get the right actor, because in previous instances where we've named the wrong actor, if it ever gets to ethics or if we're dealing with this, then it's like right problem, wrong person, and we're screwed.
Well, just from my experience, so for the 6254 assertion, I would think that the sergeant would be the appropriate person, since he made the assertion to us. I'm not sure whether that's training. I'm not sure whether that's a line that records are legal or the Office of the Chief of Police holds. But in her role as the head of the Office of the Chief of Police, Lynn Tomioka does bear significant responsibility for this stance on records in my professional dealings with the police department. 6254F denials have come back with her imprimatur on it, and quite frankly, I think we should frankly have her here to address this issue. It's a very significant issue. SFPD is not forthcoming with information. When approached with the public, the stance that incident reports produced by public servants in service of the public are, by definition, not public records unless deemed otherwise by law enforcement, which is a parajudicial agency, is an extremely alarming assertion. And I think that the city, and I think it behooves this task force to look very closely at this issue, because quite frankly, it's something that my colleagues in the press don't do enough of.
Well, we certainly are going to talk more about the police at EOT. That's absolutely on the list. If you want to name Ms. Tomioka,
Yes, I think Ms. Tomioka would be appropriate to name on this. Quite frankly, I would like to invite her here to discuss these issues at a future date.
Okay.
Who can I just follow up? Who else would we name in this? Just her?
No, I think
Ms. Conifrey? I mean, at a minimum, it seems to be that it's Ms. Conifrey, but it doesn't really go anywhere. I'm sorry, we need to figure this out, is my point.
Member David.
Yeah, I can appreciate Member Winston's frustration with the San Francisco Police Department. I just think that we should really, as the task force, be focused on this particular case and not a general, right? And I definitely have some concerns that there's violation here. I also want us to simultaneously take into consideration that we are, in this specific case, talking about a domestic violence report. And I just want to be at least thoughtful of the fact of the last thing I want to do is unintentionally send a message that people should not be filing domestic violence complaints because it's going to be sunshined, right? I just want to be very kind of careful about how we frame this in the way that it does not discourage those types of complaints. Okay.
I think that the violation we would be finding here would not be withholding the documents. It would be failure to provide an explanation about why the information was withheld. So,
and further, that some of the details could have been revealed potentially, but that's
right.
Secondary.
Member Rommel.
Is there a way to leave it open? So, assuming we find a violation of the fact that they didn't provide a forthcoming explanation for why they withheld the information, and we send it back to the police department and they review it carefully, and they look at the fact that they never brought charges and the fact that a restraining order was never issued, and they say, okay, maybe in fact this will not threaten the safety of a person involved, then that actually would then be a violation of the Sunshine Ordinance if they released it because they didn't, in the first place, make that assessment. But so, I mean, that's kind of counterproductive, actually, now that I think of it, to find them in violation once they actually release it. But if there was a way that we could maintain the case so that it did not go away, but so they could file the full explanation that we actually need to make the decision.
Well, where I see this going, if this motion passes, then the logical place to send it would be to Education, Outreach, and Training, so that we could continue this conversation, and so that we understand further, and that the police department understands how we read the ordinance, and I think that would be helpful to everybody. All right, at this, Member Pilpel, if you could, I'm looking at the time and what else we have on the plate. So.
Can I just ask Deputy City Attorney Kola, do we actually have to name an individual, or can we just find the police department generally in violation on these sections and refer it?
Well, where is it that you want to refer it?
Well, it sounds like Joe Washburn indicated that it will probably go to EOT.
Okay. The only concern that I see that would arise is you'd need an actual individual if you were going to go to ethics.
But if we're not?
If you're not,
maybe not.
I don't foresee any issue with it.
I was actually thinking of adding, not sending a knowledgeable person, no disrespect to the sergeant, but it would have been nice to have Ms. Tomioka here at the outset. I don't know if that's a little...
Sergeant Pedroza did all right.
So from her job description on SFPD's website, Deputy Chief Tomioka manages the below-listed units, quote, which help the public understand SFPD and its mission. This includes legal, media relations, risk management, internal affairs, and professional standards. So I absolutely think Deputy Chief Tomioka is the individual at whom, in the command chain of SFPD, this complaint should be directed.
Okay.
Or the finding, rather.
So the motion would name her in particular, okay, which was the intent of the motion, as I understand it. Okay, at this time, I'd like to hear public comment on the motion before us.
Could you repeat the motion with the named actor, please?
Mr. Young.
The motion is to find, just finding my position. The motion is to find Lynn Tomioka of the San Francisco Police Department in violation of Sunshine Ordinance Section 67.24G and 67.27D as in dog.
So I'm going to respectfully speak against this motion, which I know you may find shocking. I am not here speaking as anyone other than a private citizen. I want to make that very, very clear. But I think what you need to do to take a member Rommel's suggestion is that you should table this motion and table this complaint to a subsequent meeting and not refer it to EOT. I think, Chair Washburn, that Deputy City Attorney Cola, should be tasked with researching with all of the public safety departments in the city and the Department of Emergency Management what their individual policies are on withholding certain types of records as not being public records at all. I know some of the departments have similar concerns that Ms. Tamioka has, and that there are specific requirements about what kinds of public safety records can be released to members of the public who are involved with the legal matter or the civil matter, but that those very same records are not releasable to just anyone and not to members of the media who want to put in requests for those same records. And so I think DCA COLA needs to absolutely research this for you by reaching out to all three of the major public safety departments, police, fire, sheriff, and toss in Department of Emergency Management, and have him give you an explicit list of what kinds of records are permissible under 6254 as being the citation to refuse the release of certain records. And then I think the task force needs to reach out to folks like Ms. Tamioka and other PIOs in those three public safety departments and tell them exactly how they have to word the rejection of release of certain records so that the departments get on the same page of what language they have to use to include those citations. Thank you.
Thank you. Is there additional public comment? Okay, the matter is back with the task force. Any further comments? Member Pilpin?
I think over here we were just conferring about the named parties, and since both Ms. Conifrey and Ms. Tamioka authored letters in response to the records request, I think I'd like to name the two of them. Even though Ms. Conifrey is not in that position anymore, she apparently is still with the city. But anyway,
Just a second. Does the second accept the addition?
Pending the deputy city attorney's comment.
I would just be wary of due process concerns and finding someone in violation when they weren't actually individually named as a complainant or as a respondent. I understand that Ms. Conifrey did offer a response in this matter and that her letter is cited in here, but the complainant made no specific allegation against her, and because of that, I don't think she felt the need to appear.
Mm-hmm. No, she wasn't required to appear.
It's just something the task force might want to consider.
Okay.
On that, I do not accept the...
All right, that's fine. I'll withdraw it.
Okay. Mr. Young, would you call the roll on the motion, please?
On the motion, Member Rummold.
Aye.
Rummold, aye. Member Winston.
Aye.
Winston, aye. Member Pilpel.
Aye.
Pilpel, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
No.
David, no. Member Fisher.
No.
Fisher, no. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes.
All right, so this will go to EOT. All right.
Do you have any instructions to the committee?
I think it's important to, and actually the suggestion that from Mr. Manette Shaw about having DCA COLA do some research for EOT would be helpful, and for the rest of us as well, in preparation for this meeting, so that we understand, you know, what the laws specify and how our law enforcement bodies, as far as you can determine, tend to interpret them, so that we'll have that background when we have Ms. Tomioka appear would be helpful.
We'll request Ms. Tomioka, and I would suggest that we have a discussion about the handling of police incident reports and how the public has access to or not has access to.
Right.
Yeah.
No.
Could you repeat that, please, so I can...
That we'll request Ms. Tomioka and have discussion about public access to police incident reports.
And...
among other things.
Well...
anything else?
And pertinent to this particular case, we need to have a discussion about how to respond to a member of the Republic when you're withholding information, to be specific about this and be helpful.
Yeah, response letters.
Sufficient, yeah.
If the chair may, if we are going to schedule some sort of hearing or have a conversation with Deputy Chief Tomioka, hopefully with Deputy Chief Tomioka or another member of the police department regarding this matter, I would also recommend that we have either an attorney who deals with freedom of information issues, or a member of the press, or someone else who deals with the disclosure of records of the public, to provide context on when information has been withheld and has not been withheld, and how other law enforcement departments around the state deal with this matter. It's not, I think that having some sort of balance to that conversation, and also having a broad discussion about sections of the California Public Records Act, like 6254F, is, I think it's imperative. It behooves us to do
Are you volunteering to be on the EOT?
I think you just did.
Yeah.
Member Washburn?
There he goes.
I heard that. Member Fisher?
Yeah, I think what Member Winston said resonates, but I believe we have a Freedom of Information lawyer sitting on my right.
Yes.
Okay.
Another EOTC member.
Right. So whether or not either or both of you are on the committee, you'll certainly be invited to participate. Okay.
I have that order of determination. I will write that description into that order.
Okay. Thank you. At this time, Mr. Young, or do we want to take a 5-minute break, or?
The gentleman from the grand jury has been here all night.
Oh my God, he's here again.
So I just feel like we should do this.
Well, we should forge ahead. Okay.
Take a break after.
Okay. So, yes, here's an item that, Mr. Young, would you read the next item on the agenda?
Item number 7, file number 14065, Civil Grand Jury Report, Ethics in the City, Promise, Practice, or Pretense.
Through the chair, a point of order, or a point of information, or a point of inquiry. How is this agenda item going to be tackled? Are you taking it in the order of the 6 separate recommendations that you have to respond to? Are you doing all of them all tonight? Or are you going to split them up across 2 subsequent meetings so that you can't possibly, within 30 minutes, get through 6 separate items?
Mr. Manette Shaw, I was going to have a conversation with the members of the task force about how to handle this. I knew that it would be late. There's a lot to cover. I wanted to mention that we have some documents were included in the packet. And I hope you've all had a chance to at least look at the pertinent parts of the grand jury report. You have the template for our response, the particular items we are to respond to. And we have had already two opportunity. Well, we had an initial opportunity at the last full task force meeting to hear from members of the civil grand jury. We've also, this was on the agenda for EOT and for compliance and amendments. And there was material in your packet about. Well, from EOT, we have what was forwarded to you without recommendation. Is a memo from Member Pilpel with his personal recommendations and reflections. This was forwarded to you without recommendation. From Compliance and Amendments, you have you had a draft by me of notes, not recommendations, notes, and then Member Hepner did a masterful job of fleshing that out. So what we're offering to you are not recommendations, they're just notes from a conversation where we reported on what members of the civil grand jury told us. We had some questions that we broached that we wanted to capture. So, that's kind of the state of where we are. So we have, excuse me, if you would let us figure out how we're going to move forward. I'm
just curious how you're going to break it up.
We don't know yet. We haven't decided. We're going to talk about that. It would have been great if we had been able to take this up an hour or two ago, but that didn't happen with our complex cases. So now it's 8:30. We have one member of the civil grand jury here. I don't see the chair, or I'm sorry, the foreperson here any longer. We have the foreperson pro tem here. So I just very quickly, your thoughts on how to use I would hope we could go at least 30 minutes here tonight. So what makes sense? What's the sense of the group here? Thoughts? Member Hepner?
My thought is this is our we've put down our thoughts for the first time for the civil grand jury members, and I would again be interested in hearing Mr. Ravensway's reflections on the comments that we've laid out, both in our report and in Mr. Pilpel's report, as one way of just hearing his reflections on that, and then maybe we can make some more final decisions after hearing his comments on our comments.
So I'm hearing that we would like to spend the time that we scheduled on this matter, that we do have another meeting, full task force meeting on August 6th. At that time, we do need to start finalizing our response by then. So we are in a bit of a time crunch. But let's, I would like to hear from Mr. Ravensway, since he's been here all evening, very patient. And this is an opportunity for members to ask questions of him. You've had some time to think about all of this, and so thank you so much for your patience.
I think one thing I'd like to sort of point out, and maybe it wasn't really clear in the cover letter that came to the task force, is basically, what you need to do is look at each of the findings. All right, there's certain findings and recommendations we ask for your response on. Okay, look at the findings, say whether you agree or disagree with each finding, and give some rationale if you disagree and things like that. And then with the recommendations, there's a certain kind of structure of we're going to do it, we're not going to do it, it's not our business, whatever. But I think, particularly on the findings, there's some room for you to make some statements, from the perspective of the Sunshine Task Force, how you look at things. And even with recommendations, whether you disagree with them or whatever, there's some room to, talk about sort of your reasoning and how the situation strikes you. Because part of this is really all about putting issues into a public forum for discussion. Things that aren't going to be framed this way in any other circumstances. I mean, a lot of your issues are coming to you in these cases, and you'd really kind of like to break out the issues at hand, but you're kind of stuck with the facts and circumstances of the case. And what we're trying to do here and with the Ethics Commission as well is to put some of these things just kind of out as an issue, as a matter that can be discussed, and sort of see how people want to frame them and talk about them, or not talk about them, as the case may be. And because of this, and because it's a rather lengthy report, I realize some of our recommendations aren't phrased as perfectly as they might be. And there's reasons why, you're going to look at them and go, no, we don't think we ought to do them. But it would be good to put some explanation behind it as well, I think. So.
I think you can be rest assured that we'll have some our own suggestions, our own take on things. Maybe come up with some ideas that you hadn't considered, given our perspective. I'm hoping that as a group that we will be able to reach consensus on what we put forward. And that's my wish. I don't know that will happen, but that's what I'd like to see us strive for.
Okay.
Members, do you have specific questions for Mr. Ravensway?
I just had a general question, and I'm not sure if you can talk about this at this point, but I'm just curious to see how is Ethics Commission receiving all of this? What's their...
Well, I plan to go to a meeting next week. They've got their standing meeting next week, and maybe I'll learn something then.
Just curious.
I mean, we haven't, we've just been coming to meetings. We're not sort of like maneuvering behind the scenes trying to figure anything out.
Right.
We come to meetings too.
Member Pilpel.
I guess I'm wondering, Mr. Ravensway, if you wanted to comment on either or both the memo that I put together or the comments from members Hefner and Washburn.
I don't have a separate copy of the Washburn Hefner memo, so I haven't kind of marked that up at this point. Yeah. And I just see these as sort of a start of a discussion. So
Fair enough.
I'm not challenging anything or really going to make a statement one way or another on it.
So I guess to Chair Washburn, my sense would be that we not adopt responses tonight, but as you suggested, sort of talk through. That we sort of talk through each thing and see if we can come to consensus on a position and either adopt or suggest some language that could be worked on between now and the next meeting. Is that sort of where we're going?
I think that we're not ready to weigh in on a recommendation at this point. I think it's my sense of what's happening here is that members need a chance to talk about each of the recommendations and determine whether we need more information before we can. We're charged with commenting on the findings as well as weighing in on the recommendations. So I'd like to suggest that we start with the first
Good.
item and see how far we can get. Or if anyone feels strongly about one of them and wants to speak about that now. I know Member Hepner and I are most familiar with recommendations 20A and 20B. We had some time to specifically talk about those. And then I'd like to open it up for comments by members of the public, perhaps after we've talked about each one.
You mean clarification, Chair, through the chair. Do you mean you're going to start with number 11 and then ask public comment on number 11?
Yes.
Before you move to 12?
Right.
Thank you.
Okay. So beginning with number 11.
Could I also suggest, by the way, I think 11, 17, 11, 12, 17, and possibly 18 if we choose to weigh in, I suspect might be easier for us than 20. I think 20 really gets into a lot more complicated territory, some of which we're going to touch on in the next agenda item.
All right, but let's just start at the top.
I absolutely agree, though.
Okay, let's start at the top.
No,
okay. So beginning with recommendation 11.
What page of the packet are we at?
Pardon me?
718. No, stand corrected.
We start with finding 11.
So let's look at the findings for recommendation 11.
I could read it out loud.
If you would.
What page are we on online?
Page 718 of our packet.
I was right.
Finding 11 says the role of email and text messages in governmental decision-making has not been fully discussed and explored. Rules on preservation of emails and public records are very hazy, and some departmental officials told the jury they routinely delete email. Guidance from the city attorney on preservation of email is non-specific. There is no guidance regarding text messages. There is no policy that applies to private emails and text messages that further public decision-making. And if I may read recommendation 11 from the grand jury?
Yes, if you would.
It says, the Ethics Commission, in conjunction with the city attorney, should develop a policy to ensure preservation of emails and text messages consistent with preservation of other public records. The policy, along with policies on preservation of public records, should be made available for public comment. Once it is completed and published, it should be made available on City Attorney and Ethics Commission web pages that lists each department, its policy, and how to obtain documents. I was actually, the page number I referenced is Member Pilpow's document, which lays it out very nicely. Yeah.
So the matter of the findings for this matter, do we believe that this accurately captures the current state of affairs with regard to email and text messages? There's been a recent case regarding this state case that, right?
City of San Jose versus Santa Clara.
Is that something that we should ask, or we should mention in our response? Member Rummel.
Well, so that case will decide the private email and text, texts that are done on a personal phone that may involve public business, but the finding 11 to me seems much broader than that. It's the role of text messages, and they say role of email and text messages. The second sentence is rules on preservation of emails in public records are very hazy, and some department officials told the jury they routinely delete email. That to me is surprising, that there's no record retention policy surrounding email. So be it private email, the private email is a separate question that City of San Jose will answer. But official city email, if city officials are deleting their email, there absolutely needs to be some type of look at that, some type of policy directive about that.
Just looking at the local government, the Secretary of State's local government records management guide, there's a directive that all departments should develop retention schedules for records generated by their departments. So there is actually a requirement in California that you generate and retain, that you determine a period of time for which those records are retained.
Includes
and it's
emails.
on the department.
And we have that policy in the city as well, and it differs across departments and agencies. And I've often been surprised at how short a time records are kept, particularly, electronic records. We have practically infinite storage available now and easy ways to search. That wasn't the case 5 or 6 years ago, when I joined the task force, but it is now. So, I think we can be very demanding and require emails be kept indefinitely. Not
Or for longer periods.
somewhere, and not necessarily, in the department per se, but, so I don't know if we want to add anything more to the findings.
So
Member Pilpel.
on this, in my proposed response, I tried to capture a lot of that. I think I probably got it wrong on the text messages. I should have made more clear that text messages are presumptively public records. Text messages sent from private accounts may or may not be, and that's. And I was trying to get at the idea that the task force can issue guidance about this, regardless of whether or not the city attorney does. I'm not sure that we needed to, or that we need to weigh in on whether or not the city attorney should develop a policy, or I guess that's in the recommendation. But that we have a role to play here, and so I was trying to assert that a bit. So I'm certainly not wedded to this text, certainly the concept I was trying to convey, but if we want to tweak that text or start with something else, that's fine too. I just wanted to do something with this the night that I spent on it.
I also wanted to say that reading the recommendation, we're not mentioned as a body that would help develop the policy, and I think we're absolutely the logical body to, not the Ethics Commission. I don't see the Ethics Commission stepping up and doing this, frankly. They've got lots of other important things to do. This is in our purview, and that's how I'm looking at it, that we're the body to work with the city attorney. It'd be nice to get on the same page as the city attorney about something and put forth some policies and procedures that would be clear and doable and make this information readily available to the public. That's my mini lecture on the matter. Member Pilpel.
Although Mr. Van Ravensway indicated that the Ethics Commission will likely take this up next week, and that's been my understanding. The city attorney also has to respond, the Board of Supervisors. There are a number of different actors, and we may or may not agree on our responses. We may say, we're going to do this, or they should do it, or whatever. So the way these responses come together is a bit chaotic.
Well, that's kind of beyond our control,
Right.
but we can.
But we should say what matters to us.
Absolutely.
Yes, agreed.
Member Highland? Vice Chair Highland? Oh, I'm sorry, Mr. Ravensway.
Through the chair, point of order, is this an opportunity for the civil grand jury to take public comment time? And shouldn't they also be restricted to a 2-minute limitation? It's not an opportunity for the
Excuse me.
jury to explain poorly written work.
Excuse me. With all due respect, Mr. Minetshaw, there'll be time for you to make public comment on this. Vice Chair Hyland has a question for Mr. Ravensway.
Yeah, I just wanted to say within the finding about the private emails and text message, the phrase that further public decision-making, I think is particularly important because that's important both in the Sunshine Ordinance and in California law about what public records are really important. So.
Okay, thank you. Members?
So it seems that before us right now, we have the decision of whether we want to take a position, whether we want to advance a policy from the task force, and that what we're not discussing right now is what that exactly will look like, but whether this is something that we should take on. I think it is. I agree with the other members who have expressed that idea. I think this would be a nice means of being proactive and issuing sort of best policies, best practices to various departments on how to please us.
Okay, is anybody else? Okay, at this time, I'd like to hear from Mr. Minetshaw.
All right, I will try to make this as brief as I can. I think that addressing the finding, you need to be very clear to the grand jury that not all of the text messages is occurring on private cell phones. The city issues lots and lots and lots of cell phones. Those text messages, you guys should make clear that the city attorney has to develop a policy about text messages being sent from city-issued cell phones. And to do that, somebody needs to get the city to cough up a list by city department of how many city-issued cell phones have been issued. I think your response to the grand jury should be that although the Sunshine Task Force is not mentioned at all in the recommendation, that you believe that the city attorney and the Ethics Commission should reach out to the Sunshine Task Force to help develop such a policy. But I absolutely have to disagree with the recommendation in Mr. Pilpel's personal take on the universe. You should not be recommending to the grand jury or to the mayor or anyone else that they get involved in an amicus curiae brief. That's beyond your scope. It's not what the grand jury asked you, and you should not be offering some opinion about commenting on a pending lawsuit. That's not your role. Not in your role as in responding to the grand jury, whether you individually as a task force later want to consider a letter of support in that lawsuit. That's a different matter, but it doesn't belong in a response to the grand jury. And as far as Mr. Pilpel's stuff about the Education and Outreach Training Committee intending to, over the next 12 months, review this issue, you should ignore that from Mr. Pilpel, because you don't know whether in 12 months EOT is going to get to that, or who on the next EOT committee will even have any interest in that. So my recommendation to you is to make it clear to the city attorney that you want to be involved in developing the policy, and that they should do so in consultation with you. But you should stay away from anything that Mr. Pilpel said about this issue.
Thank you. Is there additional public comment on this item?
I wonder. Madam Chair
Yes.
Washburn, I just want to let you know that DCA Cola is about to leave. He might have a statement concerning his 2014-15 schedule concerning his ability to attend meetings.
I had been informed by my superiors that we were going to begin staffing just the primary meeting and no longer staffing the the supplemental meetings that we've been holding effective August. So I don't know where the task force stands on that, if they'd like that to be changed, but I thought I should bring it to everyone's attention.
So what you're saying is that you would be present for just the regular,
Just the regular meeting, but
you wouldn't
memos would still be drafted for all of them.
for the special?
Mhm.
Okay.
Huh.
Well, I'm not very happy about that, and we're planning to have 2 meetings per month for 6 months is the proposal. So I think ideally, we would like to have you attend compliance and complaints, or at least compliance, and that was the way it was before budget cuts, but we have a flush budget. So this is something that we'll be talking about in the annual report that I've been lobbying about at the clerk of the board. I certainly mentioned it in my meeting, but we would very much like to have you attend. I mean, you can see we had questions and projects for you, so.
It's nice to feel wanted. Thank you.
So, can I inquire a
Member
follow-up on
Pilpel.
that? Thank you. Through the chair. Could you take a quick read sometime through 67.21E, in particular the sentence, the Board of Supervisors and the City Attorney's Office shall provide sufficient staff and resources to allow the Sunshine Task Force to fulfill its duties under this provision, limiting your hours in a way that wouldn't allow you to be at half of our at least full task force meetings. Might seem on its face to run afoul of that. You might want to bring that up to your folks.
Oh, okay. I'll raise it with my superiors.
Okay. I don't want to get into a huge budget fight, but if we're going to try in the next 6 months to get caught up with our backlog, we're going to need your help. Thanks.
Thanks for citing the relevant measure or relevant part of the ordinance. Yeah, a letter to the clerk.
Or to the city attorney.
Or the city attorney, yes.
Well, that's probably an item 8 issue. We should probably.
Right. Let's,
Okay. We can discuss that under item number 8.
okay, all right. So bringing this back, recommendation 11 to the task force, members' thoughts, the sense of where you are right now? I'd like to hear from other members, please. Is there some agreement that the findings, as stated by the grand jury, accurately reflect the state of affairs here with regard to text messages and emails?
City cell phones?
Through the chair.
Yes.
I think it is worrying to to hear the other departments delete emails on a regular basis. So I think we should take the lead on this, as has been suggested, and do some proactive work. And I think that should be our response. That this is an area of interest to us. We're happy to take the lead. Here's what we'd like to do, and that might be our response. So we would agree partially rather than disagree partially, or agree completely, I think.
So the findings, we're okay with those. We have to respond to the findings. We have to put forth the recommendation, and we'll have another opportunity to talk about this. But am I sensing that we believe that our body is the one that has the expertise and the primary responsibility for this? It's in the ordinance, and we could be specific about cite parts of the ordinance that would support this.
Of course, I think that this is something we should weigh in on. I think that, what this presents us with is an opportunity that I think you alluded to earlier to really get on the same page with ethics and the city attorney to make sure that the three bodies are giving the same advice to departments and supervisors and the mayor. And like that's the opportunity that I think this presents us with, is that to finally get rid of the knots that seem to be showing up so frequently. So.
But as far as taking, as far as citing parts of the ordinance that indicate that this is in our purview and this is part of what we do, could we include that in the recommendation for the reason we should not only be a part of it, but possibly take the lead with this?
Wouldn't it be nice if the district city attorney was around right now to ask him that?
Yeah, it would be. Well, okay. So I want to. Am I sensing a consensus here, or is this my imagination at this late time? We're not setting it in stone, but so I'm going to put in my notes possibly the lead and cite the ordinance, and we'll wordsmith this later. Okay?
And state law that requires 2-year record suspension.
Okay. Let's move on to one more finding. It's getting late. We're running up against the 30 minutes.
Finding number 12, many departments have failed to post their source of outside funding as required by the Sunshine Ordinance. Recommendation. The jury recommends that the Ethics Commission and the Sunshine Ordinance Task Force review department websites for compliance and notify non-compliant departments to immediately post their source of outside funding or face a show cause before the Ethics Commission on why the information has not been posted.
So, Mr. Ravensway, could you give us some specifics about who some of the culprits are here? I'm wondering about the Arts Commission, the Library Commission.
I didn't look at the Arts Commission. I looked at Rec and Park. I looked at planning. You know, people that have pretty well established friends of funding. There's nothing on their websites, and it's pretty clear in the ordinance it's supposed to be there. I mean, we can scroll through other departments. We understand there was a matter that came up over the police in the past, and you know, after some back and forth, they did start putting it on their website. So it's something that does require some push.
Right. So I'm wondering for findings if we could give some specifics and, you know, so, for example, and then cite the Rec and Park and Library.
Well, I mean, have a look at their websites.
Yeah,
and,
okay.
you know.
I mean, I think that's something we could do, and then include that in finding specifics. As far as the recommendation, it's asking both us and the task and ethics to review the websites. So here we would be agreeing to do this research going forward. I think maybe to include in the findings some specifics of what we see now, and then do a comprehensive review. I think this is an opportunity to work with ethics. I think we would probably be more likely to do this, although they have a huge staff and we don't. Member Hefner.
This is something that I'll note that we discussed at our meeting, the notion of surveying various departments for compliance, and you know, with the end goal of maybe issuing a form letter to every department that is non-compliant, saying, hey, you're not complying with this, please do so, like a non-compliance notice. And that's I don't think that would be particularly challenging to put under the duties of the compliance and amendments body. Something that I'm, you know, it's a matter of just looking at a ton of websites to some extent. So something that I'm willing to take on at the beginning phases, at least.
In phases, okay. So you're right now you're talking about how this might actually happen, but I think what we need to do immediately is to reach some consensus about what we're going to recommend. Are we happy with the way it's stated now, or do we want to tweak this? And do we have a Vice Chair Hyland?
I think as a first step, maybe something as general as a letter from us to other agencies requesting detail of outside contributors, and that should be on their websites as a first step. We can then go through and comb each ones and see who needs more help in that area than others. But I think that might be a more realistic first step.
So is that something we want to include in the recommendation?
I think so.
So in broad outline, give a description of a process.
Yes.
Okay. Again, we can wordsmith this and tweak it.
On that?
Member Pilpel?
So I agree generally. I've thought about this some more since I wrote my piece on it. I was thinking that, and I started to actually draft and intend to bring back before us shortly, a letter to department heads on both the sources of outside funding and the department head calendar requirements, not asserting that they were or were not in compliance, but reminding them of their obligation and that we essentially would like to see that they are complying. And if they have any issues, let us know, or something to that end. It seemed to me that it would be more reasonable for us to do some kind of a letter to department heads rather than commit to review every single website in the city, at least immediately. I'm not saying that we shouldn't review those websites eventually, and that's what I was suggesting in here, but a letter to department heads seemed like something that we could do relatively soon.
I think that's what Vice Chair Hyland was suggesting.
And may come across a little less antagonistic.
Right.
But
I
a little more like...
accuse them of being in violation and all of that.
We may get there, but not initially.
One thing at a time.
Okay. Mr. Manette-Shaw?
Why, thank you. I'm no longer a member of the public. I'm a family member of the board. So, thank you, Chair Washburn. I have to disagree with the direction Mr. Pilpel and Member Hyland just recommended. I do not think you should contact department heads until you do review the websites of each department. I find it odd that in Mr. Pilpel's July 14th memo proposing responses on behalf of the task force, that he initially said it won't be implemented because it's not reasonable. It is entirely reasonable to review those websites. And I think what you should do in response to the grand jury is to give them an accurate estimate of how long you think it might take you to get through that review. And only after that review should you contact city departments to even mention that they need to comply. And I'll be darned, I just knew Member Pilpel was going to try to work in a reference to department head calendars. That is recommendation 18. You are not on the hook to reply to 18, and you should not even wade into that issue until you get to 20A and 20B. And with all due respect, Chair Washburn, we are now 40 minutes into a discussion that was scheduled for 30 minutes, and we've broached 2 of the 6 required responses. And so I respectfully request that on next month's meeting agenda, that you will get to as your last agenda item tonight on agenda setting, that you carve out at the beginning of the meeting an hour and a half, 2.5 hour conversation about your responses to the grand jury. Because if it's taken you 40 minutes to get through the first 2 relatively easy responses to the grand jury, and if other members of the public show up at your next meeting and want to comment for their 3 minutes, you're going to have a really, really, really long conversation. And I am just stuck on Member Pilpul saying at the outset that EOT over the next 12 months would review the websites. And then 3 sentences later says the task force doesn't believe it has the resources to individually review each website. So he can't have it both ways, right? And this is not an issue solely for EOT. It's for the entire task force. And you may need to create a temporary standing committee to look into it over the next 6-month period and report to the grand jury that you're forming a special committee to look into it. Thank you.
Thank you. All right, looking at the time, I think we're going to have to move on to the next item, and it's really incumbent on members of the task force to spend some time reviewing the grand jury report, thinking about your, how you think about these things. And so when we come back on August 6th, that we can start to nail down our recommendations, because we have to respond to this before long. So, all right? Okay. Mr. Young, would you call the next item on the agenda, please?
We need to act on a motion to continue or not?
I don't think we need a motion to continue. We're going to...
Without objection.
I'm sorry, what did you say?
No action has been taken. This item will be scheduled for the August 6, 2014 meeting of the Sunshine Ordinance Task Force.
Was that a motion to continue?
No, there was no motion. We're going to...
Just continue.
Yes.
Pretty much meeting adjourned, right?
No, we have some more. We have another item or two on the agenda. I'd like to suggest we take 5 minutes, please.
So close. We're not.
Okay, the meeting is called back to order at 9:18. Mr. Young, would you call the next item on the agenda, please?
Item number 8, Sunshine Ordinance Task Force Complaint Backlog and Possible Solutions.
All right. So we began a conversation last time at the end of the meeting about how to handle the backlog, whether or not we wanted additional committees. We have 4 standing committees mentioned in the bylaws. And there have been some very interesting suggestions brought forth by members and by members of the public as well. Last Wednesday, Victor and I met with Angela Cabillo about these very problems. She was wanting to know how they could be helpful to me, and I mentioned I wanted more time from the DCA, COLA, and so forth. But I also lobbied for reconstituting the 2 committees that have not been meeting recently, Rules Committee and the Complaint Committee. And so that was the origin of the email that you got from Victor, briefly describing the committees and asking you to weigh in with your first and second choices of these. Now, the only way to make this work for Victor's time was and he came up with this brilliant solution, that these committees would meet every other month. This could change down the road, but for now, because we also are going to be having a part of that proposal was that we would continue meeting twice a month for the next 6 months to get through the backlog. And And then while we're doing that, we'll have our committee meetings every other month. Now we have 4 committees. There will be 12 of us, 11 of us. They're only, right. And so if we want to have 3 members on each committee, at least, somebody's going to have to double up. I'd be happy to be that person. Maybe Vice Chair Hyland could be that person to double up. I really want to accommodate as many of you as possible for your first choices. So it's really important that I've heard from some of you on your choice when I was just asking you that, but now you've got to give me 2, and then I'll make some decisions and maybe kind of get back to you through Victor individually, but we need to get this in place within the next few days. So please respond to Victor. I've been making note of everybody's preferences as I've gotten to know them. If you would like to step up and be on 2 committees, let me know that. I know there was some concern raised about when the 2 meetings of the full task force was going to meet, and I thought it was going to continue as it has been, with the first meeting being our regular first Wednesday of the month, and then the special meeting coming on a later Tuesday, 4th Tuesday.
That's at your discretion. We have the meeting room for specified days each week. Month. Mm-hmm. We have, I believe we have the first Wednesday of the month, the second Monday of the month, the third Tuesday of the month, and the 4th Tuesday of the month. Any combination of hearing dates is at your discretion. The calendar I sent out was just my interpretation of what might work.
Okay.
The way I read the email, and that was my response to Victor, was it looked like it was going to be the second Monday of every month and then the first Wednesday. And the problem I have with the second Monday is that incorrect? Because I don't want to go down this path if it's not.
That was what I had suggested, but it's not set.
That wasn't my understanding. So
that's how I read it. That's why I wrote back.
I was confused, and
Well, the issue I have with that is, I already have a standing meeting the second Monday, so you basically knocked me out of all. And when I signed up for this, as I said in my email, I did it with the utmost dedication that I would be here at all meetings, but sort of feel like you're changing the rules once the game's already started. So making it the second Monday, wish I had known that, probably would not have applied.
Okay, excuse me. I have to say that I didn't open this attachment. I'm sorry I missed this. So I had assumed that we would be meeting the full task force the first Wednesday and the 4th Tuesday. So that was
Tuesday.
So then that brings up if we're going to go with the every 4th Tuesday, I have 2 issues. I personally don't have any problem with it. I don't know if anybody else does. But what does that do in terms of our absences? Now we have 24 mandatory meetings. Do we get 6 absences or 3?
I suggest that the Rules Committee meet quickly.
Well, that's my committee.
At least temporarily suspend that rule in the bylaws until we get through this 6-month period.
Yeah.
Or change it.
Or change it, yeah. The bylaws are open for changes, so that's...
Madam Chair.
Yes, Member Roca.
I don't know if it's appropriate for me to say this right now, but, I've been informed that the Mayor's Office on Disability helped Supervisor Yee staff find a replacement for me, but that has not been acted upon by the Rules Committee, and the Board of Supervisors is off next month. So,
Okay, excuse me. I have to say that 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 I
And so I don't know what that does to this task force. I don't know how long I'm going to be here, but they have informed me that they found somebody. And I have made it clear to them that I do wish to be replaced, but I will stay until replaced.
Thank you. I look forward to you continuing with us as long as you must. And we'll be sorry to see you leave, although I know you want to do that.
So
most likely September, October, sounds like.
Okay. Member Pilpel?
All right. So, several things. I'm just assuming that the 10 of us are continuing to serve for the moment until things change. So, whether that's next week or 3 months down the road, I'm assuming that it's the 10 of us. Hopefully, eventually we'll have 11. That would be nice. But in the meantime, it's us. I have no objection to continuing to meet twice a month as a full task force and going to this bi-monthly schedule with the 4 committees. I would like us to, if possible, hear 6 cases a meeting, and if that means preparing for 7 or 8, knowing that some fall down, so be it. I think that we put in a lot of effort to be here, and I should probably just stop at that point. As to the committees, again, if we're 10, I tend to think of EOT and compliance and amendments as like the standing committees, and that we're going to sort of try having meetings of rules and complaints, see if it works. If it does, great. If it doesn't, we'll do something different, but that we'll, I guess, try this for 6 months. So I would have actually 5-member committees and split up the task force, half on EOT, half on compliance, and separately half on rules and half on complaints, so that we're each essentially having 2 full task force meetings and, at this point, I guess, 2 committee meetings a month. And I just tend to think that that's what it's going to take to get through the backlog, and that if our highest priority really is to deal with that backlog, that we all need to sort of be committed, although some probably think we should be committed. So
I don't know that having 5 members on each committee and having members have 4 meetings a month is going to get us through the backlog. The committees are, I say complaints is helping us going forward, and we'll see how it goes. But I don't think having 5 members on each of these committees is necessary or even advisable.
Well,
Member, Vice Chair Hyland?
I had another idea that we talked about earlier, and just that I throw it out for the full task force, is the complaints committee, which we're thinking of resurrecting, kind of mediates complaints. You have to check to see if the complainants are amenable to that, to being heard in a subcommittee rather than the full committee. And they determine jurisdiction. They kind of do a lot of the prep work, if you like. My recommendation is, by all means, let's have the 4 subcommittees and have each of them do a little bit of complaints work. In other words, you have 2 of your regular EOTC or rules issues, and then you hear 2 cases each. That's 2, 4, 6, 8, right there, and have that going on at the same time as our full task force. I mean, there's a chance we can mediate, resolve, or certainly tighten up some of those issues that then come before the full task force, and preferably even stop them getting there.
I think that's an interesting idea, and it's one that actually Member David raised. And I think that rules has rules work to do, and EOT has EOT's work to do. I think we should try for a couple of months with complaints and see how it goes.
Probably probably wouldn't hurt for maybe the heads of the other subcommittees to attend a couple of complaints sessions to see how it works, so that if we do decide to turn that on in the other subcommittees, we know how to do it. I'd be willing to.
Okay, I think we need to be creative here. Member Rummel.
Is there a rule that says that the full task force has to hear complaints? Where does that come from?
If I may.
Member
Sure.
Pelpel.
It's pretty much 21E that when a petition is filed with the task force shall determine if a record is public, and in theory within 45 days, blah, blah, blah. It doesn't say that it can be delegated to committees. It doesn't say that it can't. I guess my thinking was if committees hear things, that there would be a recommendation to the full task force,
Right.
and we could take things on a consent calendar kind of basis. I think someone could force it to a hearing on the merits before the full task force, and I don't think we could not hear it that way if that's how they wanted it.
Yeah, I think if we start.
Do we have advice from any, has like the city attorney looked at that ever?
Not that I know of. Member David?
Yeah, I mean, I think the thing that we need to be cautious about is the 6-person vote, right? Like at the end of the day, right, there needs to be a six affirmative votes to find a violation. And so what I get concerned about is that if we do complaints down in like the committee level, that we're just going to have a rehearing of it when it comes to the full task force. That it's, I mean, you kind of see rehearings of things at committees now, and when we're even like kind of like saying like, hey, we're not rehearing this case, it kind of goes down that road anyway in a lot of situations. So I just think that if we take up cases as a subcommittee and then make recommendations to the full task force, I just don't see how we're not going to go down this road of rehearing everything. And we know that you have to have 6 affirmative votes. Like that's clearly has been told to the task force.
Can I speak to that?
Right, Vice
And
Chair Hyland.
Perhaps with, and then Member Hepner is also asking. Perhaps Victor can help us with this. From our discussions, I've got the sense that, let's say the SOTF newbies, first-time complainants, might be okay with coming before a subcommittee. We might be able to mediate it. We might be able to make it go away. That's the kind of cases that we can cherry pick for those occasions, I'm hoping. The hardliners that we see here week in, week out will probably not want to do that. They want their day in court before the full task force. So perhaps Victor can tell us whether that would even work. Maybe a minority of people would be open to being heard in the subcommittee, and if we can't resolve the whole thing, we can at least determine jurisdiction and whatnot. One other thing that the Board of Supervisors does is they hear these kind of things in subcommittee, they take their public comment in subcommittee, and when it gets referred to the full task force, there is no public comment. Now, I don't know if we can do that. I'd love to do that if we could. That might be worth looking into. Phil's shaking his head, but I'm just trying to be creative here.
Member Fisher. Excuse me. Member Fisher-Head.
Yeah, and Victor is probably going to confirm this. From what I recall from when we were scheduling, there is no cherry picking. The people that are willing to mediate directly with Victor. Again, for those of you that have not observed the work Victor does, he keeps a lot of cases from coming to us. So the people that are going to want to be heard are going to want to be heard. It's almost like there is no in between. Either they mediate with Victor or they come to us. And I mean, I have seen so many cases when I was on, EOTC and vice chair and then chair here, where we had cases literally ping-ponging back and forth and spinning around, and just like they never gathered enough escape velocity just to leave. And we still see them coming back and forth. I think that's what we need to address. When a case is closed, it's closed. It shouldn't keep coming back and popping back up again. But Victor, I'm going to let you. Sorry, Mr. Clerk, I'm going to let you just respond to that.
There will be a few that would possibly agree to a complaint committee hearing. I would say maybe 10 to 20%. So maybe that's only about 10 to 20 a year. But anything helps. In addition to that, if we do hear it at the subcommittee, we can send it up as a committee report as long as there's agreement that if they agree to it, that the committee will accept the decision of the subcommittee.
And as a report, just like the Rules Committee sent it to report to the full Board of Supervisors to nominate us in that fashion.
Yes.
But the respondent, the complainant, needs to agree to that as well.
Yes.
And they'll agree to it if they felt that justice was served, and if they don't, then they won't.
That would be my guess at what would happen. There's always the chance that the task force, as the Board of Supervisors they can pull it off the consent agenda if there is a serious concern for further discussion, but I believe that's something we want to avoid.
Mm-hmm. One thing that I had envisioned, was we have cases where the complainant's complaint is poorly formed. It's poorly communicated, but it also may be poorly formed in their own minds because they don't understand the ordinance and what we can and can't do. So I was thinking the complaint committee might be the place where we could all get on the same page about what's really going on and really, pinpoint the pertinent issues and so that there's a clear case going forward. I mean, we spend a lot of time just trying to figure out what does this person want, or there's some, like at the last case we had, and we just had all kinds of questions about, what the relevant laws said and, and so forth. So it was like that case wasn't quite ripe for us in some ways. So I was thinking of the complaint committee being a place where that could be sorted out. So those kind of cases are also cases that are very straightforward and people are clear about the record they want, and maybe this hearing would enable that to happen. Member Hefner.
I'll keep it brief but I like the idea of having a complaints committee submit recommendations, either a unanimous recommendation or a recommendation of 2 out of 3 people to the full task force, and then that would require that the full task force be sort of deferential to the judgment of the complaints committee, and not open it up to just endless discussion. I think we waste a lot of time in our fact finding during these things where it drags on for another 40 minutes. And then, if there is a question about who is on the complaints committee and whether the complaints committee is representing the full, task force, or the approach of the full task force, maybe the complaints committee is something that rotates members, so that there can be a diversity of opinion and approach on the complaints committee.
Like that, couple of months.
It also could be that the Rules Committee will meet for a few times and then will have done its work, and then we could rotate members. So, Member Rom?
Or we could have multiple complaints committees, so we have just kind of multiple panels hearing cases.
That was back to my original.
Going on at the same time, and we start churning through the backlog. And looking at 21E, I don't see anything that requires us to hold the full task force to hold a public hearing on every complaint. It says we have to make a determination, but a determination could be an adoption of a committee's,
It
opinion.
does say, though, that the task force shall hold a public hearing when requested. You'll find that in there somewhere.
Where is that?
And I remember David made a very critical point here about, a finding that a department has violated the ordinance. I think we might get pushback from all kinds of folks about a committee having that. So that the full task force would have to have the final vote. Otherwise, we're in trouble.
We have.
Member Pilpel.
Couple of things. We have had instances that are sort of like a stipulated agreement where I think it was Mr. Warfield had a complaint against the controller's office. They acknowledged that they were late and they were willing to take a timeliness violation. And I think we actually left it at that, no referral. So there may be instances like that that lend themselves to a committee hearing it with a recommendation. The two things that I would hope for in this committee process, if we try it and do it, is if we're going to hear the complaint on the merits ultimately at the full body, that the complaint committee or whatever committee is hearing it look at whatever documents are missing and whatever legal or factual analysis needs to be further explicated, because sometimes they'll come and say, oh, well, I didn't get the document. Well, where's your original request? Oh, I didn't submit it. Well, that's kind of important for us to have. And the other thing is, if there's a recommendation from the committee to memorialize that in no more than 2 pages, hopefully 1 page, a paragraph maybe, that summarizes the position of the complainant, the position of the department, and the recommendation of the committee. So we can just sort of look at that and say, oh, okay, either, yeah, that makes sense and I'm with that, or we need to delve further into the thing. And I don't know if that's one of us writing it, Victor, Nick, some combination, but that we have something before the body that reflects the work of the committee and isn't just, oh, we'll show up and we'll see what it is. But we've got to have that in advance, and that requires some time and space from a committee meeting to the full task force.
Vice Chair Hyland.
Just listening to the discussion, I really like what Member Rummel brought up about more than one complaints committee. And as I'm thinking through this, why don't we have the subcommittees in one meeting act as a subcommittee, and the next meeting be a complaints committee, and then the following meeting they come back to be a subcommittee. What they were like to be EOTC 1 month, and then your complaint the next month, you're back to EOTC. That way the work carries on, but we're having at any one given month 2 complaints committees alternating and churning, fine-tuning these cases. I don't like the idea of six cases in a meeting. I think you just lose the thread at the end. If we're going to do 2 meetings a month, full task force meetings, I think there should be 4 to 5 cases. That's just my thoughts.
Perhaps and recommendations from the committee. I mean, it could be 4 or 5 on the merits and recommendations. Yeah, okay, I could live with that.
And just, I'm sorry, to address what you said about finding an agency in violation of the ordinance from a complaint. I still think the full task force would have to vote to adopt the determination, so we'd, still be acting as a task force, so there'd still be that component of it. I also think probably what the city likes least about what we do is having to come here and send people here at 8 p.m., while we're sitting around talking through it. And, if we had these kind of separate complaint committees hearing cases quickly and at a more reasonable hour, they might be much more amenable to our work.
The right people.
Yeah.
So I'm wanting to wrap this up because I'm. I forgot to eat anything since lunch. Might be part of the problem. But so I'm wondering if, Victor, you could capture these ideas and run another schedule past us or
yes,
past me, and then we can get it out, and then.
Do you want to make any tentative assignments? I do know that there are certain members that will have trouble on certain days. I believe we can assign different meetings to different days. We can use that Monday. I do know that Member Wolf has problems with Tuesdays.
Okay.
So we'll put him on a non-Tuesday schedule.
Yes, but then he'll still have problems with
I have a wrap in my bag, but it's so messy.
I'll take that. No, I'm just kidding.
So we can do this. We can make the assignments by email, and we can discuss this. I believe.
Is there anyone here that hasn't responded to Victor that can tell him something now?
I want your first and second choices.
Because we're going to take them both. I know. I'm just joking. So EOTC is your first?
Okay. So Victor's going to capture our discussion in his magical way, put together a calendar. All of you are going to let him know right away your first and second choices are your one and only, but I'd like to hear two, please. And then we'll make it all happen.
If you've already provided it, you do not need to do it again. I do have a list from about 5 people.
Can I suggest one thing just to make it easier?
Member Highland.
If we adopt that, 1 month EOTC will be EOTC, then the next meeting will be a complaint committee, then we don't need a complaint committee. We only need 3 committees, rules, EOTC, and CNA, because each of them will in turn alternate and be a complaint committee. That might make the choices a little bit easier. So that way everyone's on a complaint committee whether they like it or not, because every second meeting will be a complaints meeting, and then you choose amongst 3 of the subcommittees. Would that make things easier?
Okay.
That is a possibility, and we can also do it as a rules committee and then have a complaint committee meeting right after that with the same membership.
Half and half.
So we can keep the agendas separated. And
No, I wouldn't mess the full task forces. They're long enough.
Okay, so Victor's going to make this all.
so are we in agreement
Clear
that
to
we would
me.
like to make the complaint committee veritable?
Yes.
Right.
Okay. We'll leave the complaint committee as a free floater to be a as needed date then. I believe we could just leave all these free floating and they can meet as needed with a tentative schedule. We don't have a set a specific date for each of these meetings.
Well, why don't we set something now and with the idea that it'll be flexible as
Yes.
needed?
I mean,
Because that's kind of the way it is now.
the members should know that they're expected to be on, the 4th Tuesday. You're there, whether it's complaints, whether it's
Yes.
EOTC meeting.
And just a warning, we really will not be able to do any specials because there is no room availability and there's no, I don't have authorization to do additional meetings.
Time-wise.
Yes.
Okay. That's another reason to use this leapfrog approach, I think.
Yes.
But we will have.
If we do that,
two
we'll have one spare day a month for special meetings if we do not constitute the complaints committee.
Yeah.
I will draft something and I will get it out.
Thank you. All right. I suggest we move on.
So we're not taking action on this now. We're going to have our next meeting and then decide at that
The next
point.
meeting is August the 6th. I do not believe having a second meeting in August is a good idea as the Board of Supervisors is on recess, and that is when most departments and the board is out of town.
Okay.
Maybe that's when we could have a rules committee meeting.
Yeah.
And in lieu of a second full task force meeting in August.
Next time it'd be complaints in September.
Yeah.
Maybe that would be a good time to, figure out what our process is going to be for getting through the backlog and also to consider the ethics report. Like, I don't think that requires folks from city agencies to be here. That's just something that we could do.
But don't they expect to hear from us before then?
Oh, I
It's
don't.
due by August 26th.
You have to deal with it by the 6th, right?
Pretty much.
August 26th. Oh, I see.
I believe August 6th, you'll need to at least have a draft of all your recommendations and assign it to the chair to finalize your recommendations on behalf of the committee or of the task force.
So I really need everybody to think about this. Get your ideas down.
Should we send those ideas through Victor to you?
Yeah, I think that would make sense.
And during this discussion, I'd just like to bring up that you had tentatively scheduled the annual report for the next meeting. I do not know if you want to postpone that until September, because it looks like the next meeting will be
The 6th?
the August 6th meeting is looking very heavy right now.
Right. I also think that we might want to,
That'd be a good thing to do for the second meeting in August when it's quiet. Along with
Unless rules is meeting. Whenever you have it ready. You don't have the annual report ready, right?
Okay. I will go ahead and draft a new item, and we can continue. No action is needed on this item, so I do not believe there's any public comment for this item.
She's gone.
The member of the public is actually a member of the League of Women Voters, and
Waiting for you for dinner.
no, she's prospective. She's my replacement. So please be nice to her.
Here? No.
Haven't scared her away.
Okay. Item number 9, approval of minutes from the June 24th, 2014 and July 2nd, 2014 meetings. I have integrated all comments provided to me correcting these minutes into the current set of minutes you have before you.
I move adoption with further corrections. Non-substantive. They just fell. They're done. That's all.
So moved.
Any public comment? Seeing none. Mr. Young, would you call the roll on the minutes?
On the motion to approve the minutes as amended, Member Rummel?
Aye.
Rummel, aye. Member Winston?
Aye.
Winston, aye. Member Pilpil?
Aye.
Pilpil, aye. Member Hepner?
Aye.
Hepner, aye. Member David?
Aye.
David, aye. Member Fisher?
Aye.
Fisher, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Hyland?
Aye.
Hyland, aye. Chair Washburn?
Aye.
Washburn, aye. The motion passes. Item number 10, announcements, comments, questions, and future agenda items.
The only, Member Rummold.
I'm sorry, but so in the last meeting, I said I would write something up about the one complaint that we deferred action on. I've written it up. I just didn't know what to do with it. So who do I send it to? What do I do? I
You can
send
send
it
it
to
to
you,
myself
and
as
then
administrator, and I will forward it to the rest of the members of the task
okay.
force.
Well, I will send that to Victor soon, and then is there any? Do we have a process for like commenting on stuff before it?
We can comment on what other members have written, but it always has to go through Victor.
Okay.
Probably would.
But we shouldn't comment to the point of reaching consensus. So
Perhaps a refresher on what we can and can't do would
Yeah.
be in order right now for the new members. Member Pilpil?
generally, one can communicate about scheduling. As to substantive issues in between meetings, one should submit things to Victor for distribution, if it's just for distribution, but there really shouldn't be back and forth on the substance of things, because that's
Between members, though, right?
Between members, yes, so long as it doesn't reach a quorum of either the full task force or a committee.
So committee members can't be talking, the three of them, because that's a...
Right.
Yeah, that's why three-member committees are more difficult. They can't really do a thing. 5 minutes. You see, it's.
But if somebody, I'm sorry to interrupt, but if somebody read what I wrote and was like, oh, I disagree with this paragraph, and sent that to Victor, that's fine, right? And he could recirculate it to everyone, or no? As long as it was included in a public, in the next, in the report?
I'm not sure I'm in a good position to answer this, because this is where you get into how do you define a seriatim meeting,
Mm-hmm.
and are you responding and just stating your position, or are you getting to a quorum of members coming to consensus on a view on the matter?
Mm-hmm.
That's where it,
Gotcha.
I mean, ultimately, if you have a recommendation as to that item, you should send it, and if Chair Washburn puts it on the agenda, then we take it up again and we vote on the thing. And if there's discussion, we have the discussion at the task force meeting.
Here's a question. Given the backlog and everything we have, it would be nice to be able to try and do some prep work, non-substantive work on the sidelines, so that when we get to full task force, we're much more efficient. How much can we do? And if so, how? That's a question I want the answer to.
Just don't make up your mind about anything.
for discussion purposes? Does he just put it out that way? Okay.
For instance, I made comments on Chair Washburn's report from the Compliance and Amendments hearing. I don't think that was violative. I mostly augmented her report, and it wasn't binding. It wasn't moving towards an ultimate decision at this meeting, though I suppose in the long run it is. Those comments are supposed to lead to a final recommendation by the full task force.
We weren't recommending anything. We were reporting.
Right.
It was information only. That's how I was thinking about it.
Right.
We weren't. And I think we made
And
that
it all
clear.
went through Victor.
Yeah, and we said these were notes about the discussion.
Mm-hmm.
I can ask the DCA COLA to provide a complete summary at our next meeting, just so we are clear on the issue.
That would be great. Yeah.
Great.
For instance, the annual report, sending you a draft.
Right, the annual report, well, yeah. But that we've done it through, you and I haven't sat down and talked about anything. It's.
I think this is actually one of the things that should be talked about at the complaint committee about complaint procedures. How do we process complaints, and how much discussion can we have, how much pre-work, right? It's a good question. I don't have a good answer. We should talk about it. And that's exactly the kind of thing that we need Nick here for.
There's nothing else. Do I hear a motion?
Sorry, just
Member
one last
Pilgo?
thing. I apologize. In addition to everything else, the Ethics Commission still has the task force referral on the Micah Ringel, John Ram case, and I believe that they're going to hear that next week. So I just wanted people to be aware. I don't know where it's going to go. It may end up the same place as the Maonki case, which is still back before us at some point, but just FYI.
So is that on Monday?
I believe so. I think we got a notice about that?
Yes.
Okay.
I'm going to be away. Do I hear a motion to adjourn?
Motion to adjourn.
Second.
Okay.
Well, we just did it. Just did it.